Bhavani counsel for the petitioner, respondent number 1. Matter stands adjourned today. Based on, give a date next week. Yeah, both sides are represented.
26/7.
Obliged.
Item 6066.
Obliged.
Yes,
With your lordship, item number 7. I may be allowed to withdraw this petition with liberty.
7.
7.
Okay. Upon instructions, Miss
A. Hussain.
A. Hussain, counsel for the petitioner, seeks to withdraw this petition with liberty to approach again. The respondents are represented. Prayer is allowed. Matters is dismissed on withdrawal with liberty as prayed for.
Obliged.
Yes.
Lordship, I have to mention kindly list the matter for withdrawal.
Lordship, I informed the other side.
You informed the other side. Okay. Item number
62.
62. On the ground that both sides are represented, on the ground that the mother of the counsel holding the brief is in bereavement. The counsel for the petitioner is in bereavement. The matter stands adjourned today, list after 2 weeks.
Okay.
Any interim order
In order may continue.
is there? Interim order is there.
That's not ever my lord. I just got informed that this.
Let me check. Interim order. Next one. Check. Okay.
May I please, your lordship?
Obliges.
Lordship, I beg to mention item number 28 of daily list, lordship.
28.
Lordship. Conducting counsel, Mr. J. Sharma is out of session, lordship.
Okay. Forest, you informed.
I have informed.
Okay. With concern of the other side, then counsel for the petitioner pays for adjournment. There is allowed. List after
2 weeks.
2 weeks. Okay.
Obliged, lordship.
Item number 1 for withdrawal.
May I please, Your Lordship?
Your name
Yes, I can.
on the prayer, upon instruction to the SI and after the process seeks to withdraw this petition. There is allowed. Medicine business and withdraw. And G. Hazarika, Counsel for Revenue Department, and Mr. M. Chitya, Government Advocate of the Center.
Obliged.
Item 2.
Item number.
Same.
Same.
Okay.
Obliged.
Supply item 55.
You want to withdraw?
Yes, sir.
Same author, Mr. Jiuddin. PWD, standing counsel for PWD, will be there. Will be there for standing counsel PWD. D North. Standing counsel PWD is present. Okay.
Most of it.
Item number 3, daily list.
Contractor bill.
Yes, my lord, case regarding non-payment of contractual bill.
Part payment has been made. Part payment has been made.
You will direct him, the matter to be paid within 4 weeks. You have filed an affidavit, you have admitted it.
Yes, sir.
Mr. N. Ahmed, counsel for the petitioner, and Mr. C.
Sharma.
C. Sharma, counsel for the
Water safety.
Water Resources Department, appearing for responding numbers
1 to 4, Lordship.
1 to 4. No, you have to correct it. In the cause list, you have made an error. You can't dispose it off. Mr. Ahmed, counsel for the petitioner is given liberty to amend the cost title. To make necessary amendment in the cost title. Which shall be done in the presence of the registrar judicial, and thereafter the matter will be listed before the court. Next, in the meanwhile, the petitioner shall also provide type copy of the fresh cost title to be incorporated in the writ petition. List after corrections are done. You see what you have done. Look in the cost title, what you have done. After respondent number 4, who is there?
Item 4,
Four also same.
4 is
Four is similar matter, my lord.
similar.
And cost title also same wrong, my lord. Mistake was taken.
Okay. Same mistake,
Yes, my lord.
okay, same order.
Obliged, my lord.
item 6,
My pleasure.
See, health would be required. I'm issuing a notice, Mr. Das.
Yes,
I'm issuing a notice in the matter.
yes, we will have to file affidavit.
Huh. But Mr. Sharma, I may tell you one of the grounds which you have taken in the repetition may not be a good ground because of interference with the with many alleged fake licenses being interfered by this court. You're aware of the development.
Not to that extent, your lordship.
No, what has happened was there are allegations with regard to members of the pharmacy council that without appropriate experience, they might have got their licenses from outside the state, or they have worked outside the state. Their experience in state is not there. So on that ground, lot number of pharmacists registration had been cancelled. Against few of those cancellations, the court has interfered. Therefore, I'm just putting you to notice because you have taken a ground that they are fake members.
But the issue here is, my lord, whether that online, my lord, voting for the purpose of
No, that is
selection of
okay,
that-
but one of the grounds taken is that they are fake members.
That those members have been deleted, rightly or wrongly, my lord.
No,
deleted by the
whatever be, but I'm just putting Mr. Sharma to
Yes,
notice.
yes.
Hmm.
I'll come up with that, matter. We'll file affidavit.
Okay. Heard Mr. A. Sharma, Lanet Senior Counsel, assisted by Mr. Your name, please? P. Deori, counsel, B. Deori, counsel for the petitioners. Mr. B. Gogol, and standing counsel for the health department. And Mr. B. D. Das, the senior counsel, assisted by Ms. A. Hussain, B. Hussain, counsel for respondent number
Respondent 6. Only stretch of the text.
6.
We don't have the copy.
Oh, acha.
Six.
Mr. MC Deka. I know him from last my college days.
But he's only a president.
No, it's okay. I'm just the name rings a bell, so therefore. In view of the nature of grievances raised in this present petition, that a notice of motion returnable in how much time?
3 weeks time.
3 weeks we issued. Requisite extra copies of the repetition we served on the learned standing counsel for the health department as well as the learned instructing counsel for respondent number 6. So, Mr. Deep for him to write from respondent number 1 to 5. Basically 1 to 5, 6, Mr. Das. As the elections, the council is under challenge. It is expected that all the respondents shall file their response prior to the next date of listing. List after 3 weeks.
Interim order.
This is an interim order. Okay, interim order passed earliest time.
No,
they
that
extended.
interim
No, there is no
order
interim.
interfered with.
The cases
By
finally exposed.
the appellate court. Writ appellate. In writ-
Appellate court.
Yes.
Oh, then I'll have to put a notice. You should notice, including notice on the prayer for interim relief. This order has
That
been,
can be hard finally, my lord, once you file affidavit.
no, this,
because
this, oh, actually, writ petition was disposed of and it
Disposed
was
of, yeah.
interfered.
Yes.
But what is the difficulty in that direction to complete the election within fixed period of time? What is the difficulty?
Typically, my lord, they were saying, my lord, election has to be done on the basis of, my lord, postal ballot. That was the
Online,
rule.
online mode. Online mode is
No,
not
no.
here.
Postal ballot, now they have changed the rules and they have got a clearance from the government. On the basis of the clearance from the government, they're saying we are going for online method. Online because the difficulty is there, my lord, the ballot paper is there. Who gets letter, who doesn't, because about 9,000, 10,000 members are there. If we issue letter, who gets the letter, a lot of complaints are there. So on taking into consideration the complaint, government has got the power to relax the rules in case of necessity. So we approached the government and government has relaxed the rules, saying that you can go for online for the time being, without giving any burden to the government. That is what they say. So this was interfered with without hearing us.
Notice including notice on the prayer for interim relief. Get another in 3 weeks. Okay.
Item 8.
Yes, after some time. Okay, what time so that he can make his time?
Just coming here,
Okay.
Lord, then lives in group number 9.
Great, you're obliged.
Item 9.
May I please your lordship?
Yes.
Item number 9, 22, 23,
It's okay,
24
one by one we'll take it up.
and 34 taken up together.
We'll take it up one by one. You have filed your affidavit in the matter, Mr. Datta?
Lord, I'm yet to file, my lord. I could not get the instruction yet.
Okay. So then we'll have to adjourn it,
My lord, possibly, my lord.
because that is the only point, only one point is involved.
Yes.
In this case, we have not served with the extra copy also, my lord.
Oh, then we'll vacate the interim order if you don't serve in the course of the day.
No, lordship, serve the copy.
I don't know.
We are ready with the copy, my lord, but no
Which
extra
one,
copy has been
lordship?
furnished.
We have served. Item
Wait
number
for him.
9.
Item 9.
Item
Show it
number
to him,
9.
we'll take it up at 2 o'clock. In the meantime, you settle it.
Lordship, item 9 notice not been issued and even,
Pardon me?
yes, item number 9, lordship. Notice not been issued.
No, but still
And-
give him a copy.
No. direction
Otherwise,
of
he'll
the-
not be able to get instructions. Give him an extra copy in course of the day.
Lordship, yes, I'll provide that.
Uh, Then I'll issue notice here and fix it together. For Mr. F.U. Barbuya, counsel for the petitioner. Mr. M. Chettiar, and government advocate appearing for respondent number
1, 2, 3, 4, 5,
1 to 5, 7 and 8.
7 and 8.
And Mr. S. Datta, and senior counsel, assisted by Mr.
K Upamanyu,
T Upamanyu, council for respondent number 6.
5 and 6.
Oh, 5 also. I think 6 only.
Executive officer 5. And 6, 5 and 6 both.
Four could be, 1 to 4. 5 and 6. This 7 will be by Panchayat. A chief executive officer, Jila Parishad, Mr. Chedia. Panchayat, who's there? So first, and 8 will be appearing, block development officer, you can appear. So instead of 7, make it 8. And for 7, you write Mr. S. Datta, standing counsel for respondent number 7. Next one. Requisite extra copies of the requisition be served on the state and departmental council in course of the day. On the prayer made by learned government advocate as well as the learned senior counsel for the respondent number 5 and 6. The matter stands adjourned to enable him to file affidavit in opposition in the matter. List after 3 weeks. List after 3 weeks. This item 20.
Item number 22, 23, 24, and 32.
32. Approval list after 3 weeks along with WBC 3892 of 2023.
Interim order.
There also say about affidavit within 3 weeks. Interim orders, past release can be extended till the limited origin.
Obliged.
Item 10,
Your Lordship.
Yes.
My lord, on the last occasion, your Lordship had put 2 questions, my lord. Firstly, my lord, whether the reputation will be maintainable since the relief in effect will be against an individual.
Yes.
And
Partnership Act.
And
Partnership
secondly,
Partnership Act.
referring to a particular clause, whether this can be, this partnership can be dissolved under section 43. Now, so far as the first question is concerned, my lord, regarding the maintainability here, my lord, your worship will kindly take note. The petitioners and the private respondents will be partners. And there are some statutory liabilities. That statutory liability is not only with the petitioners, but also with the private respondent. Therefore, my lord, the mandamus that I am seeking before your lordship will be a mandamus for discharging statutory duty. In that view of the matter, the rate will be, in my humble submission, maintainable. Even otherwise, my lord, I may refer to some case laws where the Honorable Supreme Court has, my lord, clarified this position. My lord, may I refer to one decision, my lord, Andy Mukta, 1989 to SCC publicly here.
Just a moment. आज ठीक कोई नहीं खाली আসলে কি করতে খালি পড়বে যদি আনসার just a moment. Yes.
I was referring to one decision. My lord, 1989 to SCC page 691. My lord, I have the standard robotic copy. Has your lordship got it, my lord?
Yes.
That was with regard to my lord, the maintainability of my lord, a writ petition against a my lord private college. Whether the private college discharging public duties, that will be my lord, liable, the court can issue mandamus against that. My lord, if your lordship kindly comes to paragraph 21.
Yes.
May I read it, my lord? In Prague Tools Corporation versus CA Inamul, this court said that a mandamus can issue against a person or body to carry out the duties placed on them by the statute, even though they are not public official or statutory body. I am relying on this sentence, my lord, because the private respondent has also the my lord duty to comply with his statutory requirement of filing the my lord GST return, because that involves my lord serious civil consequences, including my lord the penalty provision includes my lord imprisonment also. So that duty is there with the private respondent. By my lord stalling the functioning of the two operation of the two accounts, the petitioners have been, my lord, prevented from making their payment, and he is also liable. He is also not making the payment, my lord. He is enjoying. I don't know, my lord, what is the fun in that. Now, since there is a statutory duty imposed on him also, therefore, my lord, in this particular case, on these facts, my lord, the writ will lie. My lord, if I may rely on another decision of my lord, in fact, my lord, certain decisions have been discussed in the judgment of this honorable court. That is, my lord, 2001, volume 1, GLT 408,
2000.
2001, volume 1, GLT 408. Maharshi Vidya Mandir. The issue here was, my lord, whether a writ petition will lie against a private school. There, my lord, this honorable court has discussed several decisions of the honorable Supreme Court in paragraph 5. May I just place the book, my lord?
Just read it slowly.
My lord, paragraph 5 will be the relevant, my lord.
This is the operative part. The rest of it I don't see.
The reported, my lord, the judgment 1991 one SCC.
This case was with regard to the fees charged by the
Yes,
school.
yes.
Correct.
There, my lord, a Supreme Court judgment has been quoted. In fact, my lord, 2-3 judgments have been quoted. The founding fathers placed no limitation or fetters on the power of the High Court under Article 226 of the Constitution, except self-imposed limitation. The arm of the court is long enough to reach injustice, wherever it is found. The court is sentinel in previve is to make out justice in the given facts. Then, my lord, another judgment has been quoted. I my lord, read the relevant part. It does appear to us that Article 226, while empowering the High Court for issue of orders or directions to any authority or person, does not make any such difference between public functions and private functions. It is not necessary for us in this case to go into this question as to what is the nature, scope, and amplitude of the reach of habeas corpus, mandamus, prohibition, quo warranto, and certiorari. They are certainly founded on English system of jurisprudence. Article 226 of the Constitution also speaks of directions and orders which can be issued to any person or authority, including in appropriate cases, any government. Under clause 1 of the Article 367, unless the context otherwise requires, the General Clauses Act 1897 shall, subject to any adaptation and modification that may be made therein under Article 372, apply for interpretation of Constitution as it applies for the interpretation of an act of the legislature of the Dominion of India. Person under Section 242 of the General Clauses Act shall include any company or association or body of individuals, whether incorporated or not. The Constitution is not a statute. It is the fountainhead of all statutes. When the language of Article 226 is clear, we cannot put shackles on the High Court to limit their jurisdiction by putting an interpretation on the words which would limit their jurisdiction. When any citizen or person is wronged, the High Court will step into to protect him, be that wrong done by the state, an instrumentality of the state, a company, or a cooperative society or association or body of individuals, whether incorporated or not, even an individual. Right that is infringed maybe under Part 3 of the Constitution or any other right which the law validly made might confer upon him. But then the power conferred upon the High Court under 226 of the Constitution is so vast, this court has laid down certain guidelines and self-imposed limitations. That has been my last statement. May I just place that down? Now, here your lordship will find, my lord, the original, quotations from the Supreme Court. Those books are also here, but I can tell you. I have just read them, my lord, 11 paragraphs only. Therefore, my lord, the private respondent has also statutory duty. Therefore, in my humble submission, my lord, the writ will lie. In fact, my lord, at this stage, I am praying for a notice. Your lordship may keep the, my lord, the question of maintenance of the writ petition open. And so far as the other query that was put by this honorable court, my lord, regarding whether under section 46, my lord, the partnership can be terminated. My lord, that is an issue in the civil court. Now, my submission will be, my lord, one particular paragraph of the partnership.
No,
there.
in that context.
Right.
If you have this partnership act.
My lord.
If you have this partnership act.
Yes, ma'am.
Please come to section 7.
My lord, section 7, partnership at will. Where no provision is made by a contract between the partners for the duration of their partnership. Here, my lord, no duration has been prescribed in this, my lord,
Thereafter,
or for determination of their partnership, the partnership is partnership.
so
at
this
will.
is there.
Yes, my lord.
Determination is there. It can be determined. That provision is there in the agreement.
Yes, my lord. That is there, my lord. May I read that particular?
No, not
clause?
required.
My lord.
But now come to this.
Section 43.
No, 6.
There, I mean, you deserve to vote for my life.
Question of 6 will not arise because this I am referring to only for one limited purpose.
My lord.
Because you have taken a plea that you have issued a notice for termination, and that according to you amounts to termination.
Yes, my lord.
Now the problem starts from there. You see, rightly or wrongly, if according to you, I accept your submission that there has been a termination of the partnership, then your other plea that the other partner, private partner, has a statutory duty to perform, that will go.
Could be, my lord. But my lord, at this stage,
No, I understand, because you see,
understand.
what happens is that, let us say, you will presume that I have not declared, say, 100 rupees as my income. Out of rest of the income, I have concealed 100 rupees as my income. So therefore, on 100 rupees, let us say 2 rupees becomes taxable as income tax. Now, if I accept your submission, can tomorrow a writ be maintainable to direct me to pay a tax of rupees 2? Because it's my statutory duty to pay tax. If I'm not performing that duty, then there can be a prosecution of the income tax. Mr. Kyal is very attentive now. So now, there is a provision for prosecution, there is a provision for others, if I don't perform that statutory duty. Now, for that, can a writ lie?
now, my lord,
Because it can be extended to any n numbers of examples. Number one, let us say X is a borrower of the bank. He has taken a loan from the bank and has left. Under the contractual duty, he has to repay the bank. Now, can somebody, a public spirited person, come and say that, well, this is a borrower and a defaulter? He had a agreement, he has to perform that duty, and therefore a writ against a borrower to make the repayment. So there can be n numbers of examples.
My lord, I have got two solutions, my lord. I will look into in this manner. Firstly, my lord, whether the partnership has been dissolved or not, that is not the question before the honorable court. That is a subject matter of the, my lord, civil court.
No, because that is a plea you have taken.
My lord, my plea before this honorable court is that I have approached the bank saying that one of the partners has written a letter to you not to operate the account. And please operate it because otherwise I fail in my statutory duty. The bank does not respond to it. And that is the primary reason why I have approached your lordship.
Okay. Okay. Let me consider I pass all this in the chambers later on.
My primary, my lord, at this stage, only perhaps my notice will, my lord, solve the entire problem. Because the private respondent is, my lord, enjoying this, the trouble that we are facing. Because, my lord, as your lordship has said, in the event is, say, it is held that the partnership is dissolved, then he is free from his liability. And in the event it is held that the partnership is still there, then he has got a role. So that cannot be decided in the state petition, my lord. The only thing that your lordship will consider whether, my lord, my representation has been rightly rejected by the bank authorities by keeping silent on it.
Okay, I'll consider also this.
Otherwise, also, my lord, petitioners and the private respondent are jointly liable, my lord.
Correct.
For income tax.
No,
as well as my
other
lord,
things have,
GST.
there's no difficulty.
Even
in-
if it is dissolved, my lord, for the earlier period, from the dissolution, earlier period, he is still liable, my lord.
However, we'll not go into that aspect right now.
My priority, your lordship may keep the maintenance the issue open, my lord.
Because you see, I am of the view that once a partnership is determined, the method of determination will govern as to whether the liability, past liability remains with the existing partner or with the erstwhile partner.
That is another.
That is another, that's why we are not going into it. I'll consider and pass on this.
Highly obvious.
Yes, item 11.
Item 11.
May I please, your lordship? My lord, the petitioner, being an assistant teacher of the Lord Higher Secondary School, Gulaghat, my lord, had been allotted a staff quarter, my lord. In addition to my duties, my lord, I had been also entrusted with the duty, my lord, to look after as a superintendent of the boys hostel. My lord, I am residing in the allotted hostel since long, my lord. My lord may be pleased to find at page 17, annexure 1 is the initial allotment order, my lord.
Today, when we are taking up the rate petition, are you still the,
Yes, my lord. I am still
what you call-
in the possession, my lord, and
are you still the superintendent?
yes, my lord.
Where is the statement?
My lord, that specific statement, my lord, performing his duties as well as, my lord, at page 7, paragraph 4, my lord. Has been performing his duties of the soil for school till date, my lord, has his,
But Mr. Bhuya,
my lord,
if the school in course of its development
my lord.
wants to demolish its house,
Yes, they can,
they can.
oh,
So
I am
how can
not, my lord,
how can we give an injunction against that?
no, my lord, I am not for a life or till my position in the school, I cannot claim the, my lord, continuance that I should be allowed to continue. At least, my lord, may kindly see the superintendent duty of a boys hostel is a very risky, my lord, it's a very risky affair, so I need an, my lord, arrangement. At least government can make some alternate arrangement, my lord, for me not as a teacher, my lord, but as a hostel superintendent, my lord. Kindly, my lord, and till, my lord, that
You have our education department.
Lordship, Education Department,
We'll take it up on Friday next.
Lordship,
In the meantime, you get instructions because if he's right,
Lordship.
if a superintendent is not in the, is not allowed to, our hostel is not allowed to reside there, how will you perform his duties?
Lordship, because the instruction just now I have received, because I had a telephonic conversation, your lordship. Lordship, what had happened is that the PWD department, they have given a fitness certificate, your lordship, and what they have said is that.
No,
the-
you see, you may have experience in dealing with students, you may not have.
Lordship,
But I have some, what you call, in course of my present job, I am required to deal with students. The it's just not imaginable that somebody is a superintendent of a hostel and he does not live in that area. Very difficult. You're not seeing in your, you were young enough not to see turbulent times in student life,
lordship, lordship.
but we have seen those. As a student in the school, in the college, we have seen turbulent days. And the superintendent not residing there. Because you can divest him of superintendent,
Lordship,
you take instruction, because
sir, I'll
if he
take
is a
instruction.
superintendent and does not live there,
lordship,
somebody must take responsibility of
Somebody.
whatever happens in the students.
lordship. I'll take instruction,
Yes, yes.
Friday, your lord.
Friday.
Lordship.
Mr. A.R. Bhuyan, on counsel for the petitioner, projects that the petitioner is discharging his duty as a superintendent of the boys hostel of government Besbarua Higher Secondary School, Golaghat. The petitioner is in receipt of a notice to vacate the accommodation at the hostel for development of the school playground, as the authorities intend to demolish the said premises. Next paragraph. Miss
D. Musahari,
D. Musahari, learned standing counsel for the
Secondary Education.
Secondary Education Department, shall obtain specific instructions as to how does the authorities expect the petitioner to discharge his duty as superintendent of the boys hostel without residing in the vicinity. And if the petitioner and who is the authority who will take responsibility of the students in the hostel if the petitioner does not stay in the premises. List on 21/7/2023.
Obliged.
obliged.
Give me an extra copy also,
No, sure, I-
otherwise she will not get instructions. One extra copy, please give.
Obliged.
12 or 13 or similar একটা যে production এর জন্য allow করেছে, যেটা 12, 13 নিতে পারছেন না, নিতে পারছেন না।
সেইটো আহি থাকিব, পিছত আহিব। Yes, 12 and 13.
Item 12,
Actually, maybe passed over for the time being. Mr. Dinath is appearing. He is on legs in post number 1.
Okay.
My lord, there was some similar matters, my lord, they mentioned, my lord had permitted that. So, my lord, again, together with those, my lord, have to do it, not otherwise in coming. Similar, one case, my lord,
Okay,
here's
then
the other case.
Then
is
at
with
2 o'clock.
2 o'clock.
Yes, 14.
In persons to the order of this honorable court, my lord, the petitioner refers to the authority. In persons to the order of this honorable court, my lord, the petitioner refers to the authority for getting temporary settlement. But from the impine order, it reveals, my lord, the settlement was given to a defaulter who is having, my lord, 65 lakhs around, my lord, defaulter. To him, my lord.
It's only temporary. 15/7 was the date.
Yes. No,
Has
my
it
lord,
happened?
that
No.
is- That is in respect of other fisher. 15/7, that, my lord, NIT has been already issued. Lordship will see, my lord, lordship.
Then I issue a notice at this stage.
My lord, I am praying for the interim.
Interim I am not giving.
Lordship will see, my lord, for a moment. For a moment, my lord, how come, my lord, the authority is providing to a defaulter, my lord? Lordship will see.
No, that may be there. Whether it's a
Kindly
default
for
or
a
not.
moment, lordship will make up your
That's-
lordship.
in fact,
Interim orders I am
Clearly
not passing in
indicated,
tender matters. In this sale
Not
of fisheries
tender.
and all, I am not passing an interim order.
Lordship, kindly have a look, my lord, just for a moment.
No,
my
it may
lord.
be absolutely illegal, but still, when it is a sale or tender or this, what you call, this settlement of fisheries.
No,
I am
my
not
lord,
giving an
lordship
interim
has-
order without
lordship has
notice.
Directed us to approach before the authority. Accordingly, we approached, my lord.
No, it's
And
okay.
he
They
said-
must have some compelling reasons to do it.
My lord,
Without
the
knowing that,
impine
I'm not
order does not
interfering.
say anything about his defaulter, my lord.
No, let me issue a short notice, but not without any interim, not without notice.
And my lord, one more thing, my lord, the pendency of the case, my lord, regular floating cannot be stopped. That part, the regular settlement of the fishery by way of NIT in persons to earlier common judgment, my lord, that has to be proceeded. Lordship, for a
Where is
moment,
that?
lordship will see
Where is
at
that?
at page, my lord, 72 and 73, my lord. Lordship, everything will be clear, my lord.
72, 73.
My lord.
Is which part you want me to read?
Lordship will see, my lord, at Roman 5, my lord, Roman 4. Page 72. The order dated so and so is only referred to the extent that indicated above in a specific observation and finding to that effect. Petitioner is a defaulter and liable to pay 64,98,306 as a revenue. Entitlement for the respondent shall have been specifically dealt with in para 35. Then para 35 said, my lord, let them approach to the authority with the representation, but as my instruction as on date, my lord, they have not approached,
No, no.
nor they have deposited
No.
this amount.
Everything has been done, my lord. It's pending
Furthermore,
before them.
let
Please,
me
please don't
complete.
interfere. Let him complete.
Sorry.
Furthermore, lordship will see lordship's order, my lord, at page 83 operative part, my lord.
Page,
Page 82 and 83, my lord, is the operative part of your lordship's order, my lord. Eighty-three, para 10, my lord, is
just
here.
one, just one. Fine. Yes,
Lordship, para 10, may I read, my lord?
yes.
As operative part, my lord, as the judgment has passed on 2/3/23, 3 months' time has already been expired on 1/6/23. Therefore, the state in the fishery department appears to have not been complied with the order of the in letter and spirit. Therefore, the court is inclined to issue a direction to the principal secretary, fishery department, commissioner secretary, and secretary to the government of Assam to ensure that the said order passed in cases is complied with letter and speed. Then Lordship will see the petitioner shall produce the certificate copy of this order on the receipt of the bid from the petitioner and other bidders. If the respondent number shall take a fresh decision in respect of bid within 7 days from the receipt of the said.
This fishery, you will be appearing for the fishery. We'll take it up at 2 o'clock. I propose to issue a suo motu notice of contempt. Because in this case, we directed that the sale of fishery should be completed within 3 months. They have not asked for any extension of time.
No.
You get instructions why we should not issue a notice of contempt. We'll take a suo motu contempt. But interim order, whatever be the reasons, good reasons, but I am not
My lord,
passing any interim
no, my
order.
lord, what I'm on your lordship is that, my lord, interim order does not reflect that he is a defaulter, my lord.
It's
If
okay.
defaulter is given, my lord, he has been given clean sheet. Losing loss of the government revenue of 65 lakhs, my lord.
It's okay. That those people is, what you call, you give a complaint before the police lodge an FIR.
In fact, Malad, that issue
My
has
lord,
not been
now, my
investigated.
lord,
at
I
all.
have to lodge an affair against the official authority, my lord.
Yes,
Lordship
yes,
is
you have to do
correct
it.
in-
You have
correct,
to do it.
my
You have
lord,
to
that
get this
will-
system.
Contempt
That's
proceeding.
this honorable court interfered with that part that I'm a defaulter and asked the remission application to be decided. This is specifically what my learned friend just read just now before. That is very much there.
That's okay. At 2 o'clock, we'll take it
My
up.
lord,
Let him take instructions.
my lord.
Mr. Balbina, just give him a spare copy so that he can take instructions.
My lord, right now I'll do
To,
it.
Mr. Gil.
Right now.
Oh, not necessary. Okay. Just take information. In this matters, I intend to issue a contempt notice.
Next is
Right.
also maybe, my lord, my learned friend is appearing.
Yes.
Same feature.
Today, hand in glove.
I am the third highest bidder, lordship, private respondent is the fourth highest bidder.
Yes,
Rejecting
sir,
my
that is
tender.
why,
I
for
am
me,
the-
in fish series, everything is fishy.
Yes,
We'll take it up at 2 o'clock. With these instructions.
In fact, this petition is bad for non-joint or necessary party member. There is a dispute within his society member.
We'll take it up at 2 o'clock.
Everything is on record, lordship, I have annexed the
It's okay.
I'll make a submission on that. Also.
Item 15.
15 is same.
Item 16.
We left this also.
16.
60 law. Because this is regarding unauthorized construction of it, done by respondent number 4. Respondent 4, 5 and the petitioner.
I'm not impressed with this repetition. This appears to be a civil dispute.
Lordship,
You see, you gave a no objection to your brother who made a building and he extended his building and from the, what you call that, FAR is not maintained. That is your projection, right?
yes,
Now, when you have applied, you are not getting a permission.
Lordship, the fact is that the NOC which was issued to the respondent number 4, it was completely violation. And with
It's okay.
violation of that.
No, no,
NOC,
it's okay. But when the construction was coming up, you never objected. Now you have raised the objection when your application is not being
By
considered.
seeing the building, we cannot find that this was
Every ingredient of a civil dispute is there.
illegal, Lordship. But
Every ingredient of a civil dispute is there.
But Lordship, the respondents, the GMC and GMD, they have already issued notice, but no coercive action has been taken, Lordship. Your Lordship will find it at page 40, Lordship. As per the provisions of the Act, GMC, GMD and bylaws, they are supposed to take action if any unauthorized construction is there. We have made several representations, Lordship.
Where is your representation?
Last representation is at page 43, Lordship. Objection against the regularization of 4th floor and building margin parameters. What happened, Lordship? The original permission was for G+3. When we asked for the documents for the GMC and GMDA, they came with the notice at page 40, Annex 11, that already the fourth floor has been regularized. But it was for G+3 only, with 4 units. So we approached the authorities by the representation dated 6/6/2023.
You are appearing for respondent number
I'm
Oh.
looking for response for GMC matter.
for GMC.
Right.
Okay, then we are issuing a notice then.
My lord, as per his complaint, my lord, notices already been issued to respondent number 4 and 5, my lord. That is GMC authority.
That was issued long back, Lordship. On 24/5/2023. I
Notice to
initially
my lord.
approached the authorities in October 22. Since October, they have been,
And so they are issuing a notice, you take a response by them. Mr. D. Barwa, counsel for the petitioner. And Ms. S.
Sutia, my lord, on
Sutia.
behalf of PNI.
Learned counsel, appearing on behalf of Mr. P. Nayak, standing counsel for GMC and GMDA. And Mr. K. Gogoi, learned additional senior government advocate, appearing for respondent number 1. By referring to notice number GMDA /UC /157 /20/2022 /15 dated 23/2023, page 37. Issued by the Chief Executive Officer, GMDA, to the respondent number 4. It is submitted that no steps has been taken by the GMDA as well as GMC, who had also issued a notice to the respondent number 4 on 24/5/2023. The present petition has been filed in Article 226 of the Constitution of India. Next, issue notice returnable in 3 weeks. Requisite extra copies of the petition be served on the state and departmental council in course of the day. Next, the petition shall serve notice on the respondent, shall take steps within 2 days for service of notice on respondent number 4 by registered post with AD. So in addition, the petition shall serve notice on the respondent number 4 by way of dusty. And affidavit of service shall be filed prior to the next date of listing. Next, list on Swenson. Now, list after 3 weeks. Take steps.
Ending 8 or 7.
Time being item 8.
Yes.
Lately.
Last week in Lordship, I produced the relevant record Lordship.
Is available.
Lordship will notate in the. recording
Yes.
sheet also.
Just show me those parts where your name is Raichandani.
Lordship,
Mr. Raichandani had last time pointed out
Lordship.
that it was a proceeding under a different head, but was converted into a
I'm
different
grateful,
head.
my lords, they made a statement. Your lordship on the first occasion had directed them to produce on record the reasons to believe, not to disclose it to me for perusal of your lordship. On the last occasion, my lords, they made a statement that we have not undertaken any inquiry or investigation under 67, but under 70. And that statement was recorded on the last occasion by your lordship. I'm grateful, my lords, I'm obliged. And indeed, I bow to my learned friends, my lord, that they made a statement is under 70. Your lordship, may kindly have the act for a minute, my lords. This has been my case since inception, and I make a representation to them, which they don't deal with, and which forces me to come to your lordship with folded hands, saying that please consider this application. Kindly have the act for a minute, my lords.
CGST. CGST.
They are.
Awesome. Wow.
My lords, before my apology, my lords, before your lordships look at the section, kindly have a look at the arrangement of the chapters, my lords, before that. That will give, that is a complete answer to the submission that I'm making before your lordships, my lord. Kindly have the arrangement of the sections, my lord. There are different chapters. The entire act, my lord, your lordships are aware, any taxing statute, my lords, is divided into several chapters, my lords. Every chapter contains a certain specific provision and the roles there to my lords. Kindly have that, my lords. Chapter 1 contains the preliminary section, section 1, which says the scope of the act. Section 2, the definition clause. Chapter 2 provides for the officers and the administration under the act, my lords. Chapter 3, my lords, is the charging section, which provides for the, my apology, my lords.
Just. Just pass me your book.
Lordship, I'll just got it. He just get a copy, my lords. You just get a copy, my lords. My apology, my lords.
I think this book has abridged version.
Your lordships are aware, my lords, these days authors sell the book by the number of the pages, my lords. That's the difficulty when they add to it. My lordships are aware, my lord, the Excise Act is one of the smallest acts that we have, my lords. It contains only 44 sections. But if your lordship sees the excise book, my lords, it runs into more than 5,000 pages, my lords. It's a 44 section act, my lord, only 44 sections.
2.3, just a moment.
Lordship may have only the index, my lords. It will have the scheme of the act, the index itself.
Difficulty is that index also I can't search.
My opinion. May I just assist your lordship, my lord?
2.13.
Because we get used to how these authors write, my lords, and where they hide the index.
Yes, arrangement of sections. Yes.
Lordships, I am obliged, my lords. I am obliged. Lordship, may kindly see the scheme of the act.
Yes.
This itself, my lords, in my respectful submission for my lord's kind consideration, is a complete answer to the submission that I'm making, my lords, which falls for my lord's kind consideration, my lords. Lordship, may kindly see the arrangement of the entire act, the scheme of the entire act.
Yes.
Chapter 1 contains preliminary, which is the extent and the scope of the act and the definition clause. 2 provides for the powers of the officers. Who are the officers? Chapter 3 is for levy and collection of tax, which is the charging section, my lord, section 7, section 9, on what tax will be levied. Chapter 4 is time and value of supply. First, supply, tax is on supply. Then when taxed, on what value taxed. Then comes input tax credit, because you get credit of the taxes paid on for your purchases, my lords. Then have chapter 6, my lords, is the registration. who are liable to be registered, who are not liable to be registered, when you have to register, when are people compulsorily required to be registered, the entire, kindly see, my lords, 22 to 30 is entire registration, my lords. Then invoices, debit notes, credit notes, etc., which documents have to be issued by you, is chapter 7. Chapter 8 is, my lords, accounts and records. Lordship may note this. Accounts and records, my lords. These are the accounts statutorily required to be maintained by me. These are the records which are statutorily required to be maintained by me. I am a registered assessee, my lords. I am registered under 22 with them. I am maintaining these records under 35 and 36, my lords. Then lordships may kindly see returns. Scheme for returns. When will you file your GSTR 1, GSTR 3B, GSTR 9, annual returns, periodicity of the returns? The entire scheme of act from 37 to 53A is returns. Lordships, I am required to file my returns. I have filed my returns. There is no dispute about this, my lords. I have filed my returns. Returns may be correct, returns may be incorrect, returns may be complete, may be incomplete, my lords. That they have to question, my lords. Then comes payment of tax. Once I file my return, I have to pay the taxes. How do I pay the taxes? Under 49. Whether I'm eligible for credit from my credit ledger, from my cash ledger, that is provided under the chapter payment of taxes, my lords. Then comes refunds. Suppose I paid excess tax, my lords, I myself, because refund is a suo motu action, my lords. Suppose I find myself that I paid excess tax, I will apply for refund. Then they will grant me refund, my lords, under 54 to 58. Then comes assessment. This assessment, my lords, is very important, my lords. Assessment. Whatever return you have filed, whether it is right or wrong, somebody has to assess it. So there are various types of assessments, my lords. The scheme itself envisages all of this. One is self-assessment. I will assess myself. Suppose I find myself liable to pay tax of 100 rupees. I will pay that 100 rupees under section 49. Then, my lords, there is provisional assessment. They can do provisional assessment also. They can do scrutiny assessment also. Lords, scrutiny assessment is very important, my lords. They can do scrutiny assessment also. They can do assessment of filers of returns. They can do assessment of non-filers of returns. Entire scheme, it's a complete code, my lords. It's a complete code in itself. In my respectful submission, my lords, there cannot be anything which is wanting in the act. There is none. I'll satisfy your lordship. I'll satisfy your lordship. Once the assessment is done, my lords, they have power to do scrutiny assessment, provisional assessment, reassessment. They have power to do that. Then comes audit. Then comes audit, my lords. Lordship may kindly see chapter 13. Is audit. Audit is defined. I'll show you the definition of audit also. It's statutorily defined, my lords. It's statutorily all these terms are statutorily defined. Then comes audit and special audit. There are two powers, my lords, audit and special audit. They can give me a notice saying that we want to audit your books of accounts or records. Audit is for, my lords, anybody who is a registered assessee, who has filed his returns, who has paid his taxes. And, my lords, most importantly, there is no provisional assessment, scrutiny assessment, etc. done in his case. That means we have not found any error in your assessment, your self-assessment. But I want to still conduct audit. Your lordships are aware there are statutory audits also conducted by private auditors, my lords. Under the Companies Act also, there are statutory auditors, there are non-statutory auditors, my lords. Audit. What is the function or the role of the audit? To examine what you have submitted. Then comes, my lords, chapter 14. This is very important, my lords. Inspection, search, seizure, and arrest. It's on a completely different footing, this entire chapter, my lords. This chapter, kindly see the scheme of the section, my lords. 67 provides for inspection. It provides for inspection. My lord, with great respect, my lord, I'll satisfy your lordships. There is a difference between inspection. There is a difference between investigation. There is a difference between enquiry and inquiry. Lordship, there is a world of difference in the act itself. And there is a difference, my lord, between audit. They are not overlapping. The scheme of the act is very clear. The scheme of the act is absolutely clear in my respectful submission for my lord's kind consideration that the scheme of the act empowers you. They are not powerless, my lords. I am not even making a submission that they don't have jurisdiction. They have very well jurisdiction, my lords. They can do that. Please do that. My submission is that only. Please do what the law prescribes for. And I have no difficulty, my lords. If you seek to invoke 67 or 69 or 70 or 71 or 72, lords may kindly see all those sections. They are grouped separately. Then 73 onwards, a notice starts. Demands and recoveries. Entire scheme, my lords. 73 onwards, demand notices will be given, orders will be passed. 78 provides for recovery, 79 provides for recovery, 80 provides for attachments, etc. Those are provisions for demands of recovery, my lords. If you are invoking 70, that's the statement that they made, my lords. Their cases we issued summons. My lords, what is this summon? May I just submit for my lords kind consideration? When will a summon be issued, my lords? Will a summon be issued saying that please come here and produce books of records or books of accounts? In my respectful submission, answer is no. A summon presupposes, my lords, that there is some investigation done by us. On the basis of that investigation, we feel that your attendance is required for recording oral evidence. For recording oral evidence or recording your statement in relation to this investigation which has been conducted by me. And to take this investigation to its logical conclusion, leading to 73 notice. Lordship, this is also very important. 65 and 66 do not refer to 73, 74. 67 to 72 refer to 73 and 74. Reason is this, my lords. Reason is this, that if I am undertaking any investigation, you are entitled to. If you are undertaking any inquiry, not enquiry, it's different, my lords. Inquiry. You're entitled to, please do. But if you're doing that, then you have to provide me as to what was the reason for you to start this investigation. And if you fail to provide me, lords, I make a representation. And their answer is not that we cannot provide to you, or we have already provided to you, that the submission my learned friend was making across the bar, my lords, without an affidavit. Their reply is, we cannot give it to you because we have already issued show cause notice. That, in my respectful submission, my lords, cannot be the answer. They have to deal with my representation, my application, my lords, saying that I need these details, I need this information, I ought to have this because, my lords, in this case, you have not even issued a pre-show cause. The Act provides for a pre-show cause for this purpose only. For this purpose only, saying that we as the assessing officer or the assessing authority have come to a conclusion that we ought to issue a show cause notice to you. Please come and give a reply. There is a form called DRC 01A, my lords, which is preceding DRC 01, which is the show cause, my lords. Reason is this only in the statutory scheme of the Act. Reason is this only, that if you feel that this notice ought to be issued to you or not, please come and tell us. Or if
But is it not that unless if I disclose to you the reasons to believe,
Lordship.
then perhaps you'll manipulate the accounts and everything else.
No, this is all based. I'm grateful, my lords. That's my submission, my lords. That's my submission. If it were under 69 or 70, my lords, I would not be before your lordships. In the guise of, that's my precise challenge, my lord, my precise point, limited point for my lord's kind condition. In the guise of 67, 69, 70, don't do 65. 65 provides for a different scheme. And not just kindly now see, my lords, the definition of audit. Kindly have the definition of audit, my lords. They have done audit. Audit does not require any summons. There is no need for any summons to be issued to me. In fact, in this case, my lords, the investigation.
What is the submission in guise of in guise of?
My lords, in the guise of 67 and 70, their statement is today 70, my lords. They have done what 65 provides for. And 65 is an independent scheme in itself. Kindly have 65, my lords. Before that, kindly have the definition of audit. And I will show from the show cause itself, my lords, what they have done is audit. I will show from the show cause itself. Para by para, my lords. What they have done is actually 65. The DGJ had no business doing this. No business issuing me 70 summons saying that we have gathered information. I'm asking, yes, please tell me what is that information. They say, no, we don't have any information. My lord, may I just hand over a copy? Lordships have got that.
Yeah.
The Act. Lordships, may kindly have the definition of audit, my lords. in section 2, my lords. Lordships may kindly have 13.
CGST account का नहीं है तो ये मोटा कितना बनेगा
नहीं, ये दे दो।
डायरेक्ट सेंट्रल गुड्स एंड सर्विस टैक्स
ये दे दो। My lords may have. This is the bare act, my lords. This is the bare act.
this we should be also having it to G10 itu केस मोटा कितना बेटो G10 सब कहीं लगे हैं मतलब G10 what's happening? You purchase a book for
Lordships, yes,
no,
my
no,
lordships.
you
I
can
want-
return it because we have it. We just couldn't locate, but thank you. for-
No, no, my apology, my lords.
Ah.
We are obliged, no difference.
You can ask somebody to get it returned,
Lordships, I'll.
but thank you for your gesture.
Not at all, my lords. We are just doing our job, to assist in this court, my lord. That's my only job, my lords.
Yes, which
Lordships may kindly have section 2, subclause subsection 13, my lords. 213 defines audit.
213 last time you made a reference, we have it here.
Lordships, 213,
213.
Lordships, 213
Hmm.
defines the term audit.
Yes.
11 defines what is assessment. 13 defines what is audit, my lords.
Yes.
Lords, may I repeat it, Your Lordship? Audit means the examination of records. Which records, Lordship, I'll show your Lordship that which I'm supposed to statutorily required to be maintained. Returns, which I'm supposed to file under the Act statutorily. And other documents maintained or furnished by the registered person under this Act, or the rules made thereunder, or any law for the time being in force, in to verify the correctness of the turnover declared, taxes paid, refund claimed, and input tax credit availed, and to assess his compliance with the provisions of this Act or the rules made thereunder. Therefore, my lords, what they will do is, they will examine the records, the returns, and the documents which are furnished by me to verify, this is a verification exercise, whether I have paid taxes correctly or not, whether I have availed input tax credit correctly or not.
Yes.
Now, lordships may kindly have 65, my lords. There is a detailed procedure prescribed for it. Lordships, kindly have 65, my lords.
Yes.
Audit by the tax authorities, the commissioner or any officer authorized by him. Lordship, here the commissioner will mean my jurisdictional commissioner, because I am a registered assessor. I'm filing my returns, I'm paying my taxes with my commissionerate. Lordship, this is my commissioner. I submit myself to his jurisdiction, my lords. The commissioner or any officer authorized by him by way of a general or a specific audit order may undertake audit of any registered person for such period at such frequency and in such manner as may be prescribed. The officers referred to the above may conduct audit at the place of business of the registered person or in their office. Either lordships, they will come to my office or they can call me to their office, my lord, with the records, lordships. 3, my lords, the registered person shall be informed by way of a notice. This is very relevant, my lords. Not less than 15 working days prior to conduct of audit in such manner as may be prescribed. They have to give me a notice saying that we intend to conduct audit. Please keep the list of the rules provide for it. The list of documents, please keep them ready. Also, because it may not be readily available. Therefore, they say, and because this audit may be pertaining to previous financial years, say 17, 18, 18, 19, 19, 20, my lords. Keep these records ready. We want to come for an audit. Very well. Most welcome, my lords. Audit shall be completed within a period of 3 months from the date of commencement of audit. Provided this can be extended if subject to the satisfaction of the commissioner that it requires more time and therefore it can be extended for a period, my lords. 5, my lords. 5 is important. During the course of audit, the authorized officer may require the registered person to afford him the necessary facility to verify the books of accounts or other documents as he may require, to furnish such information as he may require, and render any assistance for the timely completion of audit. Whatever documents you want, you can ask. This is what they have done. I'll show from the show cause itself, my lords. They have conducted this entire thing without following the procedure under 65. Having resort to 70, that's their statement, my lord. They made a statement before your lordships. Having resort to 70, my lords. On conclusion of audit, the proper officer shall within 30 days inform the registered person whose records are audited about the findings, his rights. Lordships may kindly see what the statute, what the legislature wants to prescribe. About his findings, his rights and obligations and the reasons for such findings. Where the audit conducted under 1 results in detection of tax not paid or short paid or erroneously refunded or input tax credit wrongly availed or utilized, proper officer may initiate action under 73-74. This is a complete answer, my lords. It's a complete answer to what they have actually done. Now, my lords, may kindly have a look at the show cause notice, my lords. Is this what they are doing or not, my lords? Kindly have a look at the show cause notice, my lords. It starts at running page 85. Lordships may kindly come to page 85, my lords. Para 2 recognizes the fact that I am a registered assessee. I am filing my returns. I am paying my taxes, my lords. Specifically, that there is no dispute, my lords. It is not a case, my lords, where I am an unregistered assessee. Therefore, you have to resort to 67, 68, 69, 70.
Your date is 15/9 or 16/9?
My lord, this is 16/9. 16/9.
Yes.
Para 2 records that I am a registered assessee, filing my returns, paying my taxes. What is the work I undertake? What is the work I undertake, which is already within their knowledge, my lord. There is no investigation required for that. Kindly have para 3. Information was gathered. I asked this, my lords. What is this information that you have gathered? That is why, my lords, my challenge was, is there a reason to believe that some information was gathered which has not been put me to notice? And look at what information was gathered, my lords, and where they head. Kindly have para 3, my lords. Information was gathered that Messrs. So-and-so, being a works contractor, is paying royalty to the Forest Department of Assam against extraction of stones and sands from forest area, but has evaded GST by non-payment of appropriate taxes on the same. The GST on the amount paid by them to the Department of Forest is applicable under reverse charge by notification number 13 of 2017. The said entry states the applicability of GST on services supplied by the central government, state government, union territory, or local authority to a business entity. Lords, this is their case, my lords, against me. My lords, I would not have any quarrel or say, my lord, if their case was restricted to this. If they say, we have gathered some information or there is some intelligence on the basis of which I initiate this investigation. I initiate this investigation and stick to it. Lordship. It is like, my lords, when the police get information that the stolen goods are lying in my house, they will come and take the stolen goods. They will not come to my house and start opening my cupboard and saying that, where did you purchase this jewelry from? Where did you purchase it? No. No, my lords. In my respectful submission, answer is no. This is related to that, my lords. That there is a specific information, there is a specific intelligence on the basis of which I act. Please do not start a fishing inquiry. Their board circular says that, my lords. Section 70 board circular, it says, don't issue summons for fishing inquiry. You have 65 for that. You have 65 for that, invoke 65. Reason is this, my lords. They don't want to go to 65 and they want to stick to 70. Reason is this, my lords. I'll tell you, lordship. Lordship, this is to trouble the SSC, who is a registered assessee with you, my lords. Kindly see para 4, my lords. On receipt of information by the DGGI, my lords, what is this information? I don't know. DGGI investigation. Lordship, investigation based on para 3. Investigation has been started. It is not an audit, my lords. Investigation is under 67, 68, 69, 70, 71. I'll show that, my lords. It is not under 65. Investigation against so-and-so was initiated. Subsequently, summons under 70 were issued for submission of documents and recording of the statements concerning the instant investigation. That is only this investigation. During the course of investigation, summons dated so-and-so were issued to Messrs so-and-so under 70. In response to the said summons, Shri so-and-so appeared. His statement was also recorded, my lords.
Yes.
And now kindly see para 6, my lords. This is where my grievance starts, my lords. Had you restricted your investigation to the specific information which you allegedly are acting on the basis of that, I have not paid GST on the royalty which is payable by me to the Forest Department of the state of Assam. That's their case, my lords. I would have no grievance, my lords. 6 is where the story changes, my lords, and they go to 65. Kindly have 6, my lords. Kindly see what are the documents. Submission during the course of investigation. Again, they are again and again saying investigation, my lords. It is different, my lords, from an audit. It is different from an examination. It is different from an inquiry. Investigation, my lords. It's, my lords, with great respect, it's on a very high pedestal, my lords. During the course of investigation, the authorized representative submitted copies of the following documents for necessary investigation. Will you ask me for documents for investigation? Or you will ask for audit? Or you will ask for examination? Or you will ask for inquiry? Kindly see what are the documents, my lords? Statutory records which are there with them. Copies of balance sheet for the financial year 17-18, trial balance for 18-19. Copy of the ledger account of forest royalty for 17-18, 18-19. Copy of the ledger account on machinery hire charges for 17-18, a new case. Copy of the ledger statement on subcontract 17-18, 18-19, new case. Summary of payment received from the respective service receiver, new case. And now, my lords, kindly see 7. From investigation where they come to scrutiny. From where to where, my lords? Kindly see 5 I showed, para 6, now 7, kindly see scrutiny. They themselves are screening. Scrutiny of your GSTR return. Kindly see, my lords, GSTR 3B has been obtained from GST portal. You did not even ask me this. Suo motu on the portal, you have seen my return, and on the basis of that, you feel there is a non-payment of tax or a short payment of tax. Absolutely no difficulty, my lords. Follow the procedure under 65. Then if that be the case, my lords, I ask myself one simple question. If this be the case in every matter, that they can resort to 70, then 65 is redundant. 65 is redundant. 66 provides for special audits by the commissioner, my lords. That is redundant. If this, they want to do the scrutiny, kindly see, my lord, they are writing in the show cause. I will now show. Now, my lords, they have changed their path. Scrutiny. GSTR 3B has been obtained from GST portal. On scrutiny of the same, it appears that they have declared tax of so and so amount, CGST of so and so amount, SGST of so and so amount for the period 17-18, taxable value of so and so amount for the financial year 18-19. Further, while filing their GSTR return and paying their due taxes, they have availed ITC of so and so amount. Similarly, they have availed, my lords, what is this? Is pure audit. I read out the definition of audit, pure audit. It is pure examination. And they themselves say, para, further on examination of GSTR 3B, it is observed that there is a delay in payment of tax. Therefore, for delay in payment of tax, you are required to pay interest.
You are saying that the show cause notice says that investigation was issued.
Lordship,
It was instituted. Then you are referring to section 70,
lordships,
which is there in this show cause notice.
lordships.
And you are saying that it is a part of audit.
No, my lords, my submission is not a part of audit. 70 is specific information based. Kindly see 70, my lords. Kindly see the entire scheme, my lord. That's why I showed your lordships. Kindly start from 67, chapter 14. Kindly look at the entire set of chapter.
Inspection, search, seizure and arrest.
Inspection, search, seizure, and arrest. Kindly have that, my lords. 70 is in connection with this. 70 is in connection with 67. 70 is in connection with 68. 70 is in connection with 69. 70 is in connection with 71. It is not independent, my lords. I cannot read this section out of context, my lords. Then, my lords, if that be so, my lords, I am making a statement, my lords, your lordship may record, 65 becomes redundant. There will never be any audit. They can issue summon to anybody to start saying that you produce these documents, I want to investigate. That cannot be, my lords. It's based on specific reasons to believe that there is an evasion of tax. And I want to investigate that. No difficulty. You investigate. If you have a certain specific information, my lords, you cannot do a fishing inquiry, my lord, saying that you produce these documents, that document, these documents, and I will now make a case, try to find a case. No, my lords. You have to have specific information that there is a case. Not that now you show me your books, I want to find a case. They will come to my house, my lord. They will walk into my office and say, produce these documents, I want to make a case, and give me spot summons. They are doing that, my lord. On the spot summons are section 70 summons are being issued. That cannot be. And my lords, with great respect, my lords, what are 70 summons, my lords? When will somebody issue a summon to me, my lords? If I write a letter to you and you don't appear, then I will issue a summon to you. Straight away, how 70 is required? Yes. Answer is yes. 70 is very specific. Lordships, read that with great respect, my lords, in my respectful submission for my lord's kind consideration. In the scheme of the act, 70 requires your appearance for recording oral evidence, for recording your statements.
Come to that provision.
Lordships may kindly have 70, my lords. Kindly have 70, my lords. The proper officer under this act shall have power to summon any person whose attendance he considers necessary either to give evidence or to produce a document or anything in an inquiry.
So correct. So there are two, when it is or it is disjunctive.
Lordships.
One, it can be for the purpose of for giving evidence. The other
Lordships.
is for producing documents.
Lordships. I'm obliged, my lords. I'm grateful Lordships put me this query, my lords. I was anticipating this query. My respectful submission is this, my lords. A very clear and simple answer is or a document or any other thing, my lords. Lords, this is very relevant, my lords. Cannot mean your balance sheet. No, I have specific intelligence that you have hidden some documents. You have hidden some documents or things. Lordships may kindly see things. which may be relevant for the purpose of my inquiry. I have specific intelligence, my lord. That's why I made that submission. What does the police do, my lords? They have a specific intelligence that these things are in my house. Please produce those. It is in that context, my lords. Balance sheet, no, my lord. That is there with you. GSTR 3B return. They are saying we have studied from the portal. All available with you. No. 70 is for something which is in my possession, which is not available with you, and you feel the need for the purpose of inquiry. After inquiry, you may come to a conclusion, my lords, that it is not required. That is a different matter. I have absolutely no quarrel with that, my lords. It cannot be read in the sense, my lords, saying that a document here would not mean balance sheet. Here would not mean your GSTR 3B return or GSTR 1 return or GSTR 9 return, annual return. These are all uploaded. And my lords, in this day and age of GST on their portal, my lords, all my purchase invoices are uploaded. All my sales invoices are uploaded. Everything is uploaded on their portal, my lords. This would mean something which is not within my knowledge or custody. Mr. Assisi, it is within your knowledge and your custody. Please come here and give evidence on oath. Not for the purpose of submitting these documents, my lords. That 65 is there. 65 is a much bigger power than 70, my lords. There you can ask me anything. Lords, I'll read out 65 again, my lords. Kindly 65.5. There you can ask me anything. You can ask me what is my father's name also. Though it may not be relevant, you can still ask me. Kindly see 65.5, my lords. During the course of audit, the authorized officer may require the registered person to afford him the necessary facility to verify the books of accounts or other documents as he may require, to furnish such information as he may require, to render such assistance as he may require. Everything. There I cannot say no also, my lords. But 70, my lords, with great respect, the assessee has an option of saying no. Please tell me which is the specific document which you feel is in my custody. Please mention that you feel which is in my custody, which is relevant for the purpose of inquiry. Not just inquiry means there is some information, and that inquiry I have no difficulty, my lords. But kindly see what they do in the present show cause. They start with royalty not tax not paid. They go to verification of GSTR 3B, machinery hire charges from my balance sheet, or subcontractor tax paid, not paid, they are verifying. Interest not paid, interest. Is this 70? May I ask myself this question? There is a delay in payment of tax. Will you issue 70 summons to me? From my return, can you not tell me, sir, there is a delay? Please pay tax under 50. Issue a notice under 73. You don't need any investigation inquiry for that. That's what I read out, Manoj. Para 7 is that only. They are verifying my GSTR 3B and saying pay interest. This can never be, my lords. This is my submission, my lords, for my Lord Constitution, which certainly, my lords, with great respect, requires a reply from them, my lords. They cannot make a statement across the bar saying that we have done under 70, or we have done under 67, or we have done under 65. They have to state this on oath, my lords. That's my respectful submission. And, my lords, in light of the fact, my lord, that I specifically asked them this, I specifically make out, my lords, a 15-page submission I make. Give me this, give me this, give me explain this. And their answer is at page 140 in one line, my lords. We are sorry, we have already issued show cause notice to you. That cannot be the answer, my lord, with great respect. They have to deal with it, my lords.
Yes.
This is the record. We have initiated proceeding under section 17 was over. Their representative appeared. He produced documents as such. Proximate place to come to so-called notice. Thereafter, so-called notice was issued. And my humble submission, Lordship, I guess so-called notice it doesn't lie, because they will get opportunity to file their reply, and there is a provision for filing appeal and others. So this is my preliminary submission. Lordship, here in paragraph 5, page 86. Although my landlord
Just found.
Page 86.
Page
86 of the writ petition.
yes,
Paragraph 5, although my learned friend referred to, but he has not placed the entire
66,
page 86.
86.
The part of Choko's notice.
Yes,
Married, paragraph 5. During the course of investigation, summons dated 16 August 2019 and 20th January 2020, they received to Sri So under section 70 of the GST Act. In response to the said summons, Sri Santilal Jain, on the strength of authority letter dated 14th August 2019, issued by Sri Marjit Vachamatari, proprietor So, appeared before the officer of DGI Guwahati unit for submission of document and record statements in connection with the investigation. Thus, Sri Santilal Jain, authorized representative so during his appearance on 26th August 19 and 20th January 2022, subscribed statement under section 70 of the CGST Act. In this regard, a copy of summon and authority letter dated 14/8/2019 are in RUD 01 and the statement of Santilal Jain, authorized representative of Madhukasi RTU so. Sri Santilal Jain, his statement stated following facts concerning the said investigation. Then next page. 1. That Sri Mujumil so is engaged in construction of road bridge in his proprietorship firm, had obtained GST registration so by migrating from VAT regime. 2. Royalty amount are paid by Mr. Major Bhimsari against the procurement of forest produce, namely sand, gravel, stone, boulders from the site allotted by the forest department. The number 3, that the proposed. So these 7 documents were produced by him. Then paragraph 6. Submission of documents. During the course of investigation, the authority representative of so, while subscribing his statement, submitted the copies of the following documents necessary for the investigation. These documents were provided by him. That was scrutinized. Then after investigation, lordship, the supposed notice was issued to him. Now he has filed an application asking for documents. And lordship, may please to see the reply given by the authority, which is at page 140.
no, you have to just respond to what Mr. Acharya is saying, that the scope of section 70 is different from 65. So that is the only question which is required to be.
Lordship, his submission, he may make many submission, lordship, but whether it is relevant, lordship. Here we have produced the record, which clearly says that.
No, you see, it may be relevant, it may not be relevant, but he has made it.
No, lordship, cannot also, I cannot stop him making any submission, lordship.
So therefore, the question is that whether you subscribe to this submission that the compartmentalization of audit 65 and 66 is different from
Yes, that is a different
compartmentalization of
section 70.
of section 70, which is under the head of the
These are like-
investigation.
Chapter is different, lordship, and the scope of section 1765 are different, entirely different, lordship. Here, lordship, the reason for starting investigation under section 70, lordship, please to see the record, lordship. Why we have resorted to section 70 and issuing notice. to him.
And the second submission that by way of a Shokas notice, can a roving inquiry be made instead of a specific
If the matter is
pinpointed
very
inquiry.
specific, I produced the record. We said that specific on a specific point, the investigation was started. And his representative appeared. And he produced the document also. And it is not that we have searched his house and any search was made there. And so after that completion of that, Lordship, so cause notice was issued. You should have replied to that, Lordship. And Lordship, on last occasion, I had submitted one judgment of coastal container. He says that under the, although Lordship can have power to entertain, so I guess issuance of notice. But Lordship has to see paragraph 17. Paragraph 19. Probably on last occasion, I've submitted the copy of the judgment, coastal container law.
Which one?
Coastal container, which is reported in
Coastal container, yes.
paragraph 19. Not from on the other hand, we find force in the contention of the learned senior counsel, Sri so appearing for the appellant that the High Court has committed error in entertaining the writ petition under Article 226 of the Constitution of India at the stage of so-called notice. Though there is no bar as such for entertaining the writ petition at the stage of so-called notice, but it is settled by a number of decisions of this court where writ petitions can be entertained at the so-called notice stage. Neither it is a case of lack of jurisdiction nor any violation of principle of natural justice is Alice so to entertain the writ petition at the stage of notice. High Court ought to not to have entertained the writ petition more so when against the final order of the appeal lies to this court. The judgment of this court in the case of Union of India versus Guwahati Carbon Limited Supra relied on by the learned senior counsel for the appellant also support their case in the aforesaid judgment arising out of Central Excise Act 1944. This court held that the excise law is a complete code in order to seek the redress in excise matter and held that the entertained writ petition is not proper where alternative remedy under the statute is available. Where there is a serious dispute with regard to classification of service, the respondent ought to have responded to the so-called notice by placing materials in support of their stand. But the same time being no reason to approach the High Court questioning the very so-called notice. Further, as held by the High Court, it cannot be said that even for the contents of the so-called notice, there are no factual dispute. Further, the judgment of this court in case of Malali drugs and so and so, relied by the learned senior counsel of the appellant, also supports their case, where this court was upheld the judgment of the High Court, which refused to interfere with the so-called notice states. And Lordship, this section 70 was put under challenge before Rajasthan High Court, Lordship. This section 70 was put under challenge before the Rajasthan High Court. That was dismissed also.
No, he's not challenging it. He says
No,
that
no,
if you do it under 70, do it under 70.
No, we do.
If
And
you're doing it under 65, you do it under
No,
65.
but we completed the investigation as a section 70. Notice was issued, he responded to that. The representative appeared, he submitted documents. And after necessary scrutiny, what so-called notice was issued. Now the matter is pending before the adjudicating authority. Asking for the reply also. Now they said that they required some document information. And that was entertained by the officer Lordship. They could appear before the adjudicating authority, submit their reply.
No, but once you are making the understanding of the petitioner is that you are making a roving inquiry. So therefore you have to tell them what exactly you need.
No, Lordship, this is not a roving inquiry, specific inquiry is there. Lordship has seen the record, Lordship.
Go through it. Yes, anything more you want to say, Mr. Raisingani?
Lordship, just 1 minute, I'll take for a reply. I'm grateful my learned friend said that we had issued summons. Kindly look at page 132. Kindly have page 132.
132.
That is the summon that they have issued. Kindly have a look at that summon. No documents have been asked for. Nothing. They said you come here and I went there. And now he is criticizing me of attending to their summons. After I attended the summon, you have taken a U-turn. And today I'm asking, how did you do that? And they say, we will not give an answer. One, therefore, natural justice. Two, jurisdiction is involved, my lords. Kindly have page 132.
Yes, I'm there.
My lords, summons under 70, so and so. A case against so and so, address so and so regarding evasion of GST. Cannot be vague than this, my lord, but still is being inquired into by the undersigned. You are therefore called upon 70 to appear before the undersigned in person or through authorized representative from your organization on so and so date at so and so time at the office of so and so to give evidence, next statement on such matter concerning the investigation. As you may be asked, or produce documents or records mentioned in the schedule below. Where is the schedule? To depose verbally. No documents they asked, my lords, because they don't want any documents which are in my custody. They wanted my statement. I appeared, my statement was recorded. And from para 5, the story changes to para 6, where they said, now you have come, Mr. Please give me copies of balance sheet, copy of ledger, copy of GSTR return, copy of GSTR 3B. This is my submission, my lords. From there, they have changed to 65. This is precisely my grievance. Kindly look at their own summons. And when I ask them, they say, sorry, we have already issued a show cause notice. That cannot be an answer, my lord, with great respect. At least certainly not. That cannot be an answer to your lordships, my lord. When I raise that question, they can choose not to give me a reply. They are bound to give a reply to this honorable court, my lords. And the judgment, my lords, by Leonard Friend relied upon postal container, my lord, with great respect. Kindly look at that, my lord. That was a petition. My apology, my sincere apology, my sincere apology.
Yes, coastal container.
Lords, coastal, my lords, was a case where an association, with great respect, my lord, an association filed a petition and the High Court allowed that petition on the ground that no, this is not cargo handling service, but goods transport agency service. There, the Supreme Court came down heavily, one saying that it is not even against a notice issued to one of the members. The petition has been filed by the association in its representative capacity. Two, there, my lord, there was no challenge to violation of principles of natural justice, which I am pleading. There was no challenge to the question of jurisdiction of 67 versus 65 versus 70, read with 73. There was no such question. What was the challenge? Whether this is cargo handling service or GT on merits. The High Court entered into merits. That's what Supreme Court frowned upon. Mr. Don't get into merits. And Lordship may kindly see para 12. This is what the Supreme Court notes. Para 12. While considering the contention advance on both sides, the High Court has overruled the objection of maintainability of the petition and recorded a finding that services rendered by the members of the respondent association are classifiable under GTA, but not under cargo handling. High Court referred to the definition of cargo handling under 6523, Circular of 2002, and by instructions of 2008, Circular of 2015, and held that even after introduction of the new regime under 175, the activity falls within the category of GTA, but not cargo handling service. This is what the Supreme Court frowns upon, saying that the High Court should not have done this, but there are certain exceptions, my lords. If your lordships may kindly have para which my learned friend read out, my lords. Para 30, my lords, which my learned friend relies upon. Para 30. There are clear, my lords, the High Court doesn't say, the Supreme Court doesn't say High Court has no power to entertain these petitions. Certainly there are. That the Supreme Court can never say that it is power under 226 is taken away if something wrong is brought to your lordship's notice. Lordship, may kindly have para 30. On the other hand, we find contention, force in the contention of the learned senior counsel Shri so and so, appearing for the appellant that the High Court committed an error in entertaining the writ petition of the Constitution of India at the stage of show cause. Though there is no bar for entertaining writ petition at the stage of show cause, but it is settled by a number of decisions of show cause that when writ petitions can be entertained at show cause stage, neither it is a case of lack of jurisdiction nor violation of principles of natural justice is alleged so as to entertain the petition at show cause stage. The High Court ought not to have entertained the writ petition more so when against the final orders appeal lies to this court. The High Court entered into the merits of the controversy. My lords, with great respect, I have not pleaded before your lordships, I am not liable to pay tax. Or this section is wrongly invoked or that section is wrongly invoked, and why are they demanding tax from me? No. I am on the fundamental jurisdiction. How could you do this? My question is, how have you done this? Not what you have done. What you have done, I will, if your lordships hold how they have done is correct, then I am liable to answer the authority saying that now I am not liable to pay tax. But my question is on their jurisdiction. How have you done this? Please answer. And I raise a question. They don't answer that. Therefore, I am forced to come your lordships and trouble your lordships in this petition. You know?
Okay.
Lordship, I will, Lordship may come to page 132. They are asking, saying that someone was issued on 16. Thereafter also, Lordship notice was issued. Lordship may come to page 134. Their representative appeared before the authority in response to someone dated 26 August 2019. That copy has not been annexed. And Lordship may come to page 134. I so and so, authority so and so subscribe the following statement under section 70 of CGST Act on the 26th before the Senate Intelligence Officer Guwahati in response to in the summon dated 20th of January 2020. I am given to understand that section 70 of the CGST Act, read with section 193 228 IPC, the inquiry is deemed to be a judicial inquiry. Then Lordship, in response to question number 1, have you brought the documents related to sales supply of quantification of CGST liability from for Mrs. So-and-so? Answer. Yes, following documents are submitted today. There is a list of documents. All these were there, Lordship. They know that that's why they have sent submitted all documents to the authority, Lordship. Now some other submission is in me. In my humble submission, Lordship, the writ is not maintainable in view of the notice. Only notice has been issued to them, giving detailed reasons for why the notice has been issued. Let them respond to the notice, Lordship. Then law will take its own course, Lordship. Their alternative remedies available to them before the authority as well as before the Honorable Court also. So under the circumstance, Lordship, in my humble submission, the writ is only premature and is liable to be.
Mr. B. Raichandani, counsel for the petitioner. Also heard Mr. Ezekiel and standing counsel for the CGST.
Respondent number
Representing all the respondents.
2, Lordship, 1 line of my land is
Okay.
2 to 5.
2 to 5. Number 1 by Mr. K. Gogoi, CEC. You have on behalf of
K. Fukan.
Miss U Das, appearing on behalf of Ms. K. Fukan and CGC for respondent number 1. First off. Heard the submissions of both sides. Just a list on Monday for delivery of orders. Monday is 24th. 24th for orders.
Lordship. Lordship, may excuse my appearance for the delivery of the order.
No, it's okay.
Lordship.
We'll not inside.
What's it, record may be kept?
Ah, yes. As you just said, the photocopy records produced by the Garnet Standing Council for GST is retained.
Much better.
And take a break and come back.
We are obliged.
Just like this, we are not entertaining.
My lord,
You'll have to approach the jurisdictional magistrate.
my lord, I have stated in paragraph 2, my lord, kindly.
What have you said?
Yes. Paragraph 3, my lord. Kindly.
What,
Page 8, my lord.
what have you said?
My lord. I am reading, my lord.
Yes.
Get the accused person, private respondent 7 to 12 are constantly threatening the petitioner with the dire consequence. Being a lady, it is not possible for the petitioner to approve the police authorities and log out and district time necessary action against the accused person. Therefore, the petitioner approves this honorable court therefore necessary direction to the officer respondent. And here is my lord, in another paragraph, my lord.
No, you see, we are not saying you approach the police. But once the police does not take an action, you approach the jurisdictional magistrate.
Yes.
The High Court will not register a case, writ petition and ask the police to investigate. I am taking over 156 And 154 from the
sir.
judicial magistrate.
Kindly see page 15, paragraph 16, my lord.
Para 15.
Yes.
So you see, this is something we'll not appreciate. You are suffering from threat. You can't approach the magistrate.
My lord,
But-
not only threat, my lord, petitioner admitted in the hospital 10/6/2022 by the police, my lord. And she was released from the hospital, my lord, 16/6, my lord. And she,
But any difficulty in going to CJM?
my lord, I'm stating in the petition, my lord. Can you?
Writ petition we are not entertaining. I am not converting this code into 154, 156 code to deal with the ministerial powers. High Court is under 226 is not vested with that power. If you are aggrieved, if the police is not taking any action, you approach the judicial, what you call, that Priyanka Srivastav has to be complied with. You approach the jurisdictional magistrate. But to make this court into court entertaining 156(3) would be burdening myself with thousands of writ petition.
And petitioner also submitted application before the DCP, my lord.
No, you see, Mr. Ahmed, I can't fight you straight. So what I do is I come to High Court. I just give a story that the police is not doing anything and I come to the High Court. I may be right in one case, but I may be incorrect in another. I may make out a story in another case.
And there is a constant threat, my lord. From the respondent side.
Even if there is a threat, you will have to first apply before the Superintendent of Police to give you protection. Even in the day I was in school, I was under threat from some bully in the school. When I was in college, I was under threat by many people who disliked me. Not because I was right, I was always wrong. So therefore, I was disliked by everybody. And even now I am under threat. And even now I am under threat. Because a few moments back, I did not smile at Miss Hazarika. So she is angry. No, this is a repetition. You'll have to go to the magistrate. I'm not entertaining.
Lordship's orders, this is really covered by
Huh?
my lord's order.
Sakiri Vasu.
Lordship, Sakrivasu and Sudhir Askarao Tambe subsequently lordship. And my lords have also discussed all the effects of judgment in this. order.
Mr. Ahmed, we are relegating you to the jurisdictional magistrate, where whoever has got jurisdiction. In some places, it is the chief judicial magistrate who is taking up matters. For certain police stations, there are Ilaka magistrates designated. So you'll have to go to them.
I may be allowed to withdraw my.
Huh.
May not be discussed.
I'll just give an observation permitting you to move that. Mr. A.M. Ahmed, counsel for the petitioner, as well as Mr. K. Gogol, an additional senior government advocate appearing for the state respondents. Next paragraph. The learned counsel for the petitioner seeks to withdraw this writ petition and to move the jurisdictional magistrate of the chief judicial magistrate, whoever has this jurisdiction in respect of Nagaon police station. To stop with the liberty as prayed for, this writ petition stands closed. Respect.
57.
Wait, please allow. This settlement order is without jurisdiction, my lord. What has happened? There were three contenders, my lord. The petitioner, the respondent number 5, and respondent number 6. Now, as far as the respondent number 6 is concerned, my lord, though it is the, second highest bidder, but admittedly is a defaulter, a finding has been recorded in the settlement order. Now the fishery has been settled with the highest bidder, respondent number 5. But it's a, my lord, group consisting of women. My lord, there is no provision in the act, or sorry, rules to give, preference to any woman, my lord. Now, if your lordship would kindly come to last page, page 46.
I don't know, in my home ministry, I have never heard.
No, my lord, it's something, so the idea is to give benefit to the person who himself, they themselves do the fishing.
Yes,
Now, they kindly see, that
page
this is the page 46, my lord.
46.
Certified that the members of Noyan Jyoti self-help group of Notun Malang so-and-so belongs to fishermen control. Their husband and other family members are involved in fishing. So they are not involved in fishing, so how can they be, my lord? Now, please come to the NIT, my lord. NIT is at page number 23. My lord will kindly come to page 25.
Yes,
Kindly see C, my lord. Fishing experience certificate. They do not have any fishing experience certificate because it is comprised of women, my lord. Then come to 15, my lord. In respect of 60% category fishery, tenderers have to submit actual fisherman certificate. Now, where is the actual fisherman certificate in respect of members of, my lord, the respondent number 5 society? So it's a without jurisdiction, my lord. The object is very laudable, but that is an object which is not contemplated in the rules.
okay.
I may show your lordships from the vernacular at page 27, my lord.
Who's filed the caveat?
I am the respondent number 5, my
No, it's okay. Page
lord. 27, my lord.
27.
Serial number 4 from the bottom.
Yes,
মাছমৰা অভিজ্ঞতাৰ প্ৰমাণপত্ৰ সংশ্লিষ্ট মীন উন্নয়ন বিষয়ৰ দ্বাৰা প্ৰদান কৰা হ'ব লাগিব. So they do not have the experience. The members who constitute the respondent number 5 society, they themselves do not have the experience of fishing because they are women. They are not fishermen. They're wife of, my lord, fishermen. That's why in paragraph 8 I have made a categorical averment, my lord. If your lordship would kindly come to page 10,
but here it says Gati diya hoise.
my lord.
But here it is stated Gati diya hoise.
That is this ours, my lord.
Okay.
That
Oh,
is
acha,
ours.
acha.
Page 29.
Page 29, my lord, once again. Second from, my lord, yeah, go 14C or go মাছমৰীয়াৰ অভিজ্ঞতাৰ প্ৰমাণপত্ৰ. Terms and conditions of the NIT, page 29. মাছমৰীয়াৰ অভিজ্ঞতাৰ প্ৰমাণপত্ৰ. My lord, this is actually, my lord, this is a malice in law. It's not a malice in fact. We're not, attributing anything, otherwise they are the highest bidder. 651. Till that, my lord, they have not taken over possession. As on date, my lord, the earlier lessee is, my lord, having the possession. Respondent number 6.
Okay. Yes, then
Yes, my lord.
My lord, here, what happened, my lord, my self-help group belongs to women's, my lord, represented by the women's, my lord. Generally, my lord, 100% women can grow a self-help group, my lord. Here, yes. And my lord, generally what happened, my lord, as per this NIT, my lord, NIT said that the eligible candidates who belongs to the Samabhai Samiti, NGO, and self-help group. We are the self-help group. Generally, my lord, self-help groups are women's. And we are eligible, and that's why we have submitted the tender, my lord. My lord, kindly turn to page the settlement order, my lord, that has in annex here as annexer F44, my lord.
44.
44, my lord. That has been prepared on the basis of the CS, my lord. That CS has been prepared by the deputy commissioner of the Jorhat, my lord. That is in vernacular, my lord. I have it. This is the vernacular, my lord. On the basis of that, my lord, it has been prepared,
Pass it
my
on.
lord. Yeah. Yeah, lordship will find why I have been selected, my lord, we have been selected. Turn to page 45, my lord.
Yes.
Kumar Koiboto Gao Min Silpo Somavai Somiti, that is there, my lord. I am the highest bidder, my lord. I have offered that my bid value.
No, but if 100% actual fishermen are required,
Actually, what happened, my lord, we are the women, my lord. We are the women. That is known to the department also. After that, my lord, they have issued a tender. They have asked us.
no,
asked-
the very simple example which is inappropriate in
Yes.
all ways. It's just an example.
Yes, my lord.
I may be excused for making it lighter.
Yes, my lord.
You see, absolutely, there is no dispute that somebody else runs me. When it comes to my home front,
Yes.
there's absolutely no dispute that somebody else runs me. But she can't come and sit here.
That is correct, lordship. My lord, what happened, my lord?
I study in the allotted time which she gives me. I have to take my meals in the allotted time which she gives me.
While going up, we have to take permission.
That is true, my lord.
And we have to
Mr.
inform
Chaudhary,
my lord.
that would be spying.
And we'll have
I
to give the time also when we'll return.
I think you are spying on me.
No, I'm talking about myself.
And my lord, page 44, my lord, why I have been selected?
I'm sorry, Mr. Chaudhary, I just
No,
make
it's-
it moments later, otherwise very
It's all
strenuous.
part of life, my lord.
Otherwise it's very strenuous.
Maybe there will be some degree of difference, otherwise more or less the same pattern.
Because here, my lord, it is said in the settlement.
I
order,
have to
my
issue a
lord.
notice. I'll issue a short notice since you have appeared as a caveator. But till then, it has to be stayed.
Yes, yes.
Because if it is not a, you choose your time, 7 days, 10 days, or whatever. But this 7 days, at least once you are not 100% fisherman, that has to be stayed.
100%, my lord, what happened, my lord? Generally, my lord, women cannot catch up the fish, my lord.
But then it frustrates. Let
But
the, let the
as
state,
per- my
let
lord,
the
that is
state
department
tell
has
us.
issued a tender, my lord. Department
no,
has
that
issued a
is
tender.
okay.
We have been called for, my lord, that self-help group
That
has
is
belongs
only
to the
somebody
government.
else will derive the benefit.
That is okay. But if it is not 100% fisherman,
My lord, why I have been selected, this is explained in the settlement order, my lord, at page 44, my
no,
lord.
that is okay. But what about the requirement of, there is only one
100%.
requirement which Mr. Chaudhary is referring
ma'am.
to. It should be 100% fisherman. So do you fulfill that? If you, Mr. Gogoi, can you get us instructions in a shorter time?
Lordship, I will obtain instruction, otherwise, Lordship, page 46, Lordship. It's a reflect, Lordship.
Their husband is,
Their husbands and other family members, Lordship. And tender condition says that, Lordship, actual 100% actual.
no, I understand, but the fishery people may have good things to say. I don't know.
Lordship.
My lord,
Can
we
you-
are 135 members, there are only 10. That is also there.
No, that is okay, but still. If
And
you
my
can,
lord, my humble
if you can get it in a
submission
shorter time, we give a
the
shorter
scheme
notice.
of the rule does not permit.
No, Mr. Chaudhary, what I'm asking Mr. Gogoi is.
Yes, yes, yes.
Since I'm staying it,
Yes, yes, yes.
I'm giving them an opportunity. If
Oh, my-
if they
my
can
lord.
give a response in a shorter
Lordship, may
time.
direct
My
us to produce the original records, Lordship, and we'll produce it by 2 week time, Lordship.
No. You see, records will not improve
Lordship.
because this certificate at page 46 is made clear
It's-
what you have produced.
Lordship,
Now, the only instructions we require from them
Lordship.
is that whether this 100% fishermen can be diluted.
That cannot be, Lordship.
No,
Tender
but that is the
condition-
instructions
No,
we need.
no, Lordship, I can obtain instruction, otherwise, Lordship, that part cannot be diluted.
So you choose a date when we can fix the matter.
Lordship, may after 10 days or
Give us a date. 26th. 7 days time,
on 28th, Lordship.
28th. Okay,
28th,
but I'll have to
28th.
state for the time being. But Mr. K. N. Chaudhary, Honorary Senior Counsel, assisted by Mr. R. M. Dekar, Counsel for the petitioner. The impugn order of settlement dated 15/7/2023 has been assailed in this writ petition filed under Article 226 of the Constitution of India, comma, amongst others, comma, on the ground that as per the certificate dated 4/4/2023, within bracket annexure G, bracket closed, the husband and family members of the members of respondent number 6 self-help group, or 5 self-help group are involved in fishing activities. And accordingly, it is projected that the members of the respondent number 5 self-help group are themselves not 100% fishermen. And accordingly, it is submitted by the learned senior counsel for the petitioner that it would be violation of the conditions of the NIT.
As
This
well
is-
as Rule 12 of the fishery.
as well as Rule 12 of the fishery rules. Full stop. Next, brother. Mr. K. Govil, and additional senior government advocate accepts notice on behalf of respondent numbers
1, 2,
1 to 4.
loss.
Mr. D. Barwa, learned. Council accepts notice on behalf of respondent number 5, who has appeared as a caveator. Full stop. Heard both sides on the, all sides on the prayer for interim relief. So the prayer for interim relief is opposed by the learned additional senior government advocate as well as the learned council appearing for respondent number 5. Full stop. On the ground that the impugned settlement order dated 15/7/2023 has a potential of violating Rule 12 of the Assam Fishery Rules, 1953. The court is inclined to stay the operation of the settlement order dated 15/7/2023 till the next returnable date. So prior to that, you write.
Tosi may also indicate whether we can dilute the condition or not.
No, that's already inherent. I've said that because it will dilute, what you call, Rule 12. That is why I'm staying it. Before that, you write, requisite extra copies of the writ petition be served on the learned state and department, the learned state as well as learned. You have received copy
Yes.
to the learned state council in course of the day. The petitioner shall take steps within 2 days for service of notice on respondent number 6 by registered post with AD. You can serve by Dasti also.
Yes,
And in addition, notice be served on the said respondent by way of Dasti by routing the process through the registry of the court. And thereupon, an affidavit of service shall be filed prior to the next date of the stay. Then this interim prayer, no? For both sides on prayer for interim relief. Then it will come. The notice in the top you also write, the notice is made returnable on 28/7/2023. And in the last line you write, list on 28/7/2023. Yes, I'll keep it here. Achha, caveat discharge. Achha, this caveat is tagged with another case. WBC 720.
It is 4002 loss. WBC 4002 loss.
There is another case on the same line.
Achha, caveat is there. Caveat is there. Okay, caveat and discharge. Okay, I'm wrong. Caveat is there.
Yes, there is another case on the same subject, same.
Okay,
tomorrow it will be decided.
Okay, okay. This caveat is there, huh? Caveat is there, Mr. D. Barber for the caveat. Item 58.
Where please, your lordship, the petitioners board of that is dissolved or not, my lord, conducting the election, sorry, my lord, SDM. My lord, here limited period is there already one man committee has been constituted and election is my lord already my lord. My lord, only my lord, we may be allowed to participate in the elections. My
Can we
lord,
pass the same order at page 112? They want they want to participate in the process.
Yes, your lordship. Otherwise, there is another connected petition which is pending before this honorable court, your lordship, which is preferred by the present petitioners, your lordship. It is WPC 1504 of 2023. That is issue is deferred by the
1504.
of 2023, your lordship.
What is the issue there?
That was one extension of our tenure, my lord. That already infractions because they already, my lord, this.
Then I am recording your statement that it has become that petition has become infructuous,
Already.
and then only I can pass orders here.
Fine.
Okay. Mr. Hawk. Please do me a favor, you make photocopies of this page 115 order, make necessary correction and give it,
Fine.
because I won't have time to
Fine.
do it.
Fine.
Make necessary corrections and give it. Just add one para here. Para 3, you add new one. And existing paragraphs will change. Huh? Para 3 would be, at the outset, the learned counsel for the petitioner has submitted that the present petitioners have also filed another writ petition being WPC 1504 of 2023, wherein the petitioner has made a prayer. Petitioners have made a prayer for extension of their tenure as board of directors of which society?
Bhuragaon Samabay Samiti.
Bhuragaon, BHURAGAON Samabay Samiti Limited. Stop. It is submitted that as the board has already been dissolved and a one-man committee has taken over the affairs of the said society and elections have been announced, that petition has become infructuous. Stop. The set stand of the petitioners is taken note of. Then you write this. Please make corrections. And in the lawyer's name, you write Mr. N. Hawk for the petitioner and Mr. G. Bordole, learned standing counsel for the corporation department. Rest he will correct him. Huh? Make necessary corrections and give it. But then I have saved time.
59.
Yes.
May, please, your lordship. Lordship, in this case, lordship, may I take lordship, page 28, lordship.
No, you do not take me anywhere.
Yes.
Because of the fact that from your tone and tenor of your writ petition, I understand that you have not even understood what you are in fact reading. You have seen the pipeline rules. No, Pipeline Act you have not seen. Under the Pipelines Act, names I don't know, you will give me the names. Under that Pipeline Act, what happens is that you get a ROW. ROW is right of way.
Right.
You don't acquire any right title interest over the land. Correct?
Yes, lordship.
Correct means you have understood or not? That's
Yes,
my.
lordship. But the things is that, lordship, that
So,
embankment.
no.
was there, lordship,
Let me
long
tell
ago.
you. Under that act, there is also a provision that you are prohibited from doing any construction or erecting any embankment. You have that act.
What has happened here?
No, no,
because-
have you had that
No,
act?
I haven't brought the act because I'm not covered under the act. What has happened here is
Just
1964.
one, just one.
Yes, Your Lordship.
But that will be unnecessary exercise of
No,
hearing.
I have taken that instructions. This was a land acquired in 1961 under the Land Acquisition Act of 1994. We had absolute
You
owner
will
of the
not,
land.
you will not acquire the land.
1961, under Land Acquisition Act, land was acquired by us. That is how the records are, Lordship. We are the absolute owner of that land. The ROW for All India Limited regarding this particular piece of land, we are the absolute owners.
No, then you will never say ROW. You will say ownership. You,
It's
you can't have the right of ownership and then claim that you have ROW.
No, ROW is a nomenclature that they are using, but I have
But
seen the
that is-
record.
But
They-
that is incorrect.
Yes, the nomenclature
can-
may be incorrect, but the fact is the status is of absolute owners. Land was acquired in 1961 itself, Lordship.
But the same land was lordship limited in the name of this petitioner lordship.
No, no, you
because
see
their
this.
lordship last 35 years lordship. That was not raised prior to that lordship, only because of public complaint, this issue has come.
No,
lordship.
whatever is there is there.
But
But
that embankment is there prior to that lordship appearing of this petitioner lordship.
it will not be there. It will never be there. Because when a pipeline goes, they will not permit an embankment because it weakens the
This is totally new.
line.
Lordship.
You look at this act.
His sale papers are
See-
2021.
See section 3.
The 62 Act. Lordship. The land was acquired in 61 prior to this act. So that time,
Oh, acha, okay.
that is
okay.
why I inquired. I took the instructions also.
Okay.
Therefore, I'm
So
not
if,
covered.
if that act is not there, you do not read this. Because here here you will find
Now this is how they're doing.
93A.
Yes.
Scroll it up, 93A. What you are prohibited to do.
Yes. No permanent structures, nothing on that land. The DC NOC for land transfer is 2021. It took the land
93A
21.
and
Yes,
then come to
Lordship.
section 10.
But lordship, here say a lordship construction, any building or any other structure lordship.
After that 2 or C, ABC, you will see that C is embankment.
Tank.
Any bank, any
Dam,
so
dam is there lordship.
correct. So that can't be made.
Lordship,
But
that-
he has not acquired land under this. He says the land acquisition has taken place. So we'll give you notice. Friday we'll take it up.
Yes, you know.
can it
I'll
be
bring
on
the
next
original
week,
papers
lordship?
also.
Huh?
Can it be on next week?
Monday,
Yes, lordship.
24th. Okay.
Yes.
But Mr. B. Chaudhary, counsel for the petitioner, as well as Mr. A. Sharma, and counsel for the respondents. Next, as agreed to by both sides, list on 24/7/2023 in the motion column. Okay.
Oblige, you know. In fact, he had written a letter to us. I brought that letter wherein he admits and he says, give me 6 months time, I will remove the embankment. I have brought that letter also.
Okay. Be that as it may.
Oblige, you
We'll
know.
continue at 2,
Oblige.
61.
61, whatever Mali here, name is all right. Only in place of father's name or mother's name is has been given my own. In place of father's name, mother's name, Rahima Begum is given. Actually,
Where?
in a lost order, is,
In the lordship, in the court order, we don't give mother's name.
yes, but it is there.
Where?
Page 12, my lord, the motivation application.
Yes.
Tahibur Rahman, son of Rahima Begum.
No, no, this will not be a court mistake. You'll have to file an application for correction of the cause title.
Yes, I filed this application for correction. But in my petition, it's all right. Matlab Ali. In my petition, my lord,
No, in your petition also page 2, Rahima Begum, we are copying from there.
page 2, my lord, there is,
Look at your bail application.
yes.
What you have said is what you get.
That's why you have to write with the physical correction.
Page 2 is your cost title in the
Yes,
bail
yes,
application.
I've seen, my lord. Should be father's name, my lord. Rahima Begum, it should be, it is mother's name. Our mother's name has come, a mistake, my lord.
Now,
I think
after bail is
it-
granted,
it-
after bail is granted, now the father is coming out
No, my lord.
to,
Whatever, in
to
fact,
own
what
his
is-
son,
since-
otherwise he has
No,
disowned it.
whatever, my lord, since he's in jail, my lord. So they couldn't meet him, just got the signature from the jail, my lord, in the Akratana. And they asked the the assistant jailer to ask the father's name. He came with the mother's name. That is the mistake.
It's okay. Whenever I get the injury, first thing I shout is Ma.
Ah.
Correct. So therefore,
So it is not where, my lord, mother's name is also justified. But in
no,
the,
no, no, just give me.
but
No, no.
in the FIR, it is
You
not.
amend this application, make it an application for amendment of cost title. Because this is not a mistake in the order. It is a mistake in the cost title. You, by hand, you make this correction, we'll take it up tomorrow.
Main application, my lord.
In this interlocutory application, this application will be an application for amendment of the cost title of the bail application.
Yes.
That correction.
Yes, but in the matter of Tahidur Rahman alias.
No, 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 no.
It is there, my lord.
No, no. In your cost title of this IA, come to page 1.
Yes.
In the first, in the matter of,
Yes.
yours is an application of modification of the order. My order is not required to be modified. This should be an application for amendment of your original cost title. Make corrections in your application. This IA, right? Heard Mr. R.P. Sharma, then senior counsel for the senior counsel, assisted by Ms.
Sahin.
Yes, sir.
Yes, sir.
As hoc counsel for the applicant. And Mr. Ajay Barwal and AVP for the state. Expera. The learned senior counsel for the petitioner has submitted that error is kept in the cost title of the original bail application. And not original, make it BA 1204 of 2023, and accordingly, the praise fund is granted liberty to amend the cost title of this interlocutory application to make it as an application for modification of the cost title of BA 1204 of 2023. So the said correction shall be done in the by hand in the presence of the registrar within bracket judicial, and thereafter the matter would be listed before the court. I'll send it today. You before the registrar judicial, you make the corrections.
Yes. Always.
Production listed with the ILS.
Yes, item 12.
My lord, 12, 13th, and there are two matters, my lord, in the.
Yes, sir, I'll take one by one.
One by one, man. My lord, take up item number 12. The others would be covered, my lord,
Okay.
except for one point. My lord, what had happened here is, just if I can give a background, my lord. My lord, there were tenders issued by the work for different works by the PWD. Now we participated. My lord would find there are two petitioners. One is a company, and the petition number 2 is one of the directors. Now, this petitioner company was formed by three persons, my lord. Merging. Before that, the petition number 2, he was an independent contractor, class 1A contractor. He had enough works with the PWD in different wings of the PWD, NH, border, etc. Now, my lord, when the company was formed and he became a director, he decided to surrender his license. And my lord, the company, it was agreed that the company would take over his works. Whatever works he was doing, the company would take over. Accordingly, my lord, in the NH division, in the National Highway Division, the chief engineer, the competent authority passed an order saying that as his license is no longer, he surrendered the license, he cannot apply for any further thing in his name. All the works that is under NH, he is now transferred to the petitioner company. Now we applied, I'll tell the later story what is happening. Then even in pursuance to this tender process, we applied. Now in the tender, there is a requirement that we must disclose the ongoing works.
And then again, a question. If it is a story, why should we hear it? If it is a fact, then it
It's
is
a fact, Malad.
Oh,
It's a fact. It's a
Okay.
fact in a
It's
form
okay.
of a story. Then what happened, Malad? We applied, and whatever works were transferred to us by the PWD, we disclose that. The assessment is made by the Technical Evaluation Committee. The committee, my lord, thereafter writes to the various authorities. And from there, they get a reply that from the border wing, they get a reply that there are 4 works which is being done by the petition number 2, which is not included in the tender. So, my lord, my tender was rejected. Now, why these 4 works were not included? In the PWD border wing, my lord, these works were not transferred to the company. These works continued under the petition number 2. And my lord, the payments were being made to the petition number 2. Now, as those works did not come to a company, my lord, we could not declare those in the my lord, in our thing. Now, why this is required? This is required to assess the bid capacity. There is a requirement for assessment of bid capacity. In one of the briefs, one of the cases, the other point by which this case, my lord, only point is I have not disclosed this work. Now, I have brought on record, there are 3 cases. In all the other 3 cases, my lord, I'll show from records, the contractors who have been now, my lord, tenderers who have been held to be irresponsive, they had similar works, which was not disclosed. For me, my lord, it's legally not possible for me to disclose those works because that were not taken over by the company. But therein, those contractors were having those works, they have not disclosed it. But I was shut and they were allowed to be, my lord, cleared. Whereas my case, my lord, because of the petition number 2's works were not handed over or assigned back to the company, we could not declare it. They have, my lord, held our tender to be non-responsive and our, my lord, bid security has been forfeited. Now, the other point, my lord, in 2 cases, what has happened is they have, my lord, said, I don't have the bid capacity. Now, there is a particular formula to calculate the bid capacity. My lord, I have made those calculations available on record. By that calculation, my lord, I have the bid capacity. Now, one of the private respondents there, that is item number 12, 13, my lord. One of the private respondents, my lord, there is a value called N in that formula. N is the number of years or months that work is to be completed. Work means the tendered work is to be completed. In that tender, the work is to be completed in 180 days. That means 6 months. Now, my lord, we calculated with 0.5 because it will be half 0.5 we calculated. He calculates with 0.2. He calculates with 2. He gets a very high amount. And then, my lord, you got to deduct the ongoing commitments. Then you come to a value, which value must be more than the bidded, the tendered amount. Now, if the value of N is taken as 0.5, which is the correct value, my lord, his will become negative. But still, that tender has been cleared, my lord, whereas my bid has been kept back. If I can take my lord in the first case, straight to the, my lord, tenders, if my lord can have page 39, that is the work. I'll first, my lord, establish my eligibility, then I'll take the respondent numbers, private respondents. If my lord can come to that page 39, it's 11,423. The work is given, my lord. Periodic renewal of Nakum Rupai bypass from so-and-so, so-and-so. Value is 19 crores 29 lakhs odd. Page 39, my lord. Completion is 12 months. My lord has got it. Now, my lord would have the bid capacity. I'll just place that, my lord, so that my lord can have, we can get over with that. Page 54.
Just a moment, that was page.
First was page 39, wherein the work and the value of the work is given.
Yes, 39.
39. Then 54, although in this case, this may not be required, Mala, in the next case, this will be required. Or can I place this, my lord, in the next case itself, my lord?
You do it in one
Yeah,
go.
54, my lord. 54.
Yes.
Bid capacity. I'll just read that, my lord. Bidders who inter alia meet the minimum qualification criteria will be qualified only if their available bid capacity is more than the bid value, with value as per clause 1.1.1, that is, my lord, 19 crores 29 lakhs. Here. The available bid capacity will be calculated as per following, based on information based in Annex 6, so and so. Assessed available bid capacity, my lord, will only have this. A into N into 2.5 minus B plus C. This is the formula. Here N means, my lord, number of years prescribed for completion of work for which bid is invited. So this is 1 year, so that N will be 1. Now, fine, that's it. My lord will have page 62. Verification and disqualification. Because we have been now disqualified under these clauses.
No, just a moment. Now, with this page 54
Lordship,
is assessed,
maximum value.
no, A is assessed value.
You know, Madam 55, my lord would find it. Maximum value of civil engineering works, which I have got.
Huh.
Then
So
B is
therefore,
value.
therefore, let us take an example.
Lordship,
You just have a pencil or pen with you.
Lordship,
We take this A at rupees 100.
Lordship.
This is the maximum bid value.
Maximum
No, my maximum amount received. But the amount received, my lord will have 55,
Maximum value of civil engineering works, including so and so,
which I have got, my lord,
last 5 years.
last 5 years.
So for 5 years, let us take is 500.
500.
Correct.
Hmm.
More than that, I can't calculate.
No, might not, my lord. It was problem for me also. 500 would be problem. Then, my lord,
Mr. Kumar is doubting. I don't know how he did manage, but his face shows a question mark.
Well, I was in commerce. I knew by all those chains and other, they can calculate with the 5 fingers. We have to use side pencil and rubber. They will calculate with the 5 fingers.
now, my lord, B is the value of the works for ongoing commitments, which I have already started and it's ongoing. B.
Hmm.
Say, my lord, it should
No,
be
we will come to N first.
N,
In
my
the
lord, is
formula, N is number of years.
number of
prescribed.
years,
Number of years prescribed is 6 months.
6 months. My lord, we'll take it as, let's take it as 1 year for understanding the issue, my lord.
No,
Let
since we are
us-
doing the calculation, I am just making it 6
0.5,
months.
0.5. See,
No.
if a value of N is 1, my lord, half would be 1 year is 1, then, my lord, it will be 0.5. Or, my
No,
lord, will have to
6 by 12.
6 by 12.
It comes to same thing, but for arithmetic sake, we do it 6 by 12.
6 by 12, then value will come, my lord, 2. It will be 2, my lord.
That's what I'm coming
It
to.
cannot be, my lord, because why I'm saying so, if N value of N is 1, if 1 year, because other contracts I'll show, my lord, where it's 1 year, here also, the N is calculated as 1.
Then we go by what Mr. Nath interprets.
You'll also
He will
1
add
by
into-
6 by 12, 1 by 2. You will become
0.5,
0.5 only.
0.5 only.
It
Again,
will
my
not be
lord,
2.
right.
It
no,
will
it
not
won't
be
be 2,
2.
my lord.
Not 2.
It will not be 2.
It will be 0.5.
Huh.
So if it is 0.5, my lord will see into 2.5,
Into 5 into
2.5.
2.5.
This is constant.
This is constant. 2.5 is constant.
Huh. Minus B. Now what
B.
is B?
B is, my lord, the number of works I have in my hand. The value of that.
Okay.
That,
So-
my lord would find the note. The statement showing value of all existing commitment works for which the contractor has emerged as winner of the bids as given by the bidder, and ongoing works as well as stipulated period of completion remaining for each of the work listed below should be countersigned by so and so, so and so, so and so.
So let us take it 1000.
1,000. So it would be, my lord,
No, minus B, then plus C.
plus C. The bonus,
Amount
my
of
lord.
bonus
That, my
received.
lord, cannot, that,
Zero.
that, it's 0. Put it 0.
Plus 0. So this comes to 250 into 2.5 is 625 minus 100, it becomes negative.
So my lord now will try with 2. My lord has done 2. 500 into 2. 500 into 2.
So then it will be positive then.
Positive.
Okay.
In the second case, that is exactly what had happened. The private respondent's bid was made positive by that aspect. I'll show that one.
Okay.
Here, my lord would see the minutes. my lord.
So almost near
Yes, madam.
that 5 finger.
Clear.
You said I am almost near to it.
Yes.
2.5 into 625.
My lord will have 139, madam.
Because they have learned the 5 fingers in the mother's stomach only, in the womb.
No. It only, what do you call,
Practice.
Only Abhimanyu
practice
could-
makes a man perfect.
It's practice.
The shop from which I purchased a ration, when his elder brother sits, I ask him to do it by fingers and he'll just have this list, do it like this and write it down.
Huh.
That 5 finger theory.
Mr. Nair is counting in papers. Is good in counting papers.
He is online nowadays. Cool.
But now, this gentleman, I make it sure that when the elder brother is there, I give him this, we call it in Hindi, we call it fardi.
Yes. Just
We-
sit,
we
my lord,
give it
like
to
this
him.
itself. Then see the mental acumen then. my lord.
And whether it is 1 digit, 5 digit, 3 digit, 4
No
digit,
difference.
no difference with that.
See.
One is, say suppose sugar is 1 rupee. Any other thing I get is 1,000 rupees and another item is 100 rupees. It doesn't matter to him.
It's
It's
God's
God gifted.
gift.
It's God gifted.
God gifted.
God gifted. But no, it's a
That's why.
perfection is, it's not that Abhimanyu theory doesn't come.
No. There is no theory here. It's his understanding.
Yes.
My lord, page 139 is the bid evaluation.
That's- God, I guess. One.
39.
39.
Annexure F.
Yes.
My lord, there were 6 bidders, including the private respondent and me. And my finding, my lord, at page 140, clause 3. my lord.
Yes.
My lord, 3. Purbanchal Buildtech Private Limited. Based on the representations received, these were received from some, my lord, contractors regarding the concealment of existing commitments by the bidder named Purbanchal Buildtech Private Limited. Necessary clarifications were requested from the relevant heads of directorates, specifically Chief Engineer PWD Border Roads, through TO letter number so-and-so dated 25/5/2023. In response, the CEPWD Border Roads Assam through letter number so-and-so dated 26/5/2003 has confirmed that the bidder did not disclose the mentioned commitments in their bids. The deliberate misapprehension of facts renders the bidder liable to be disqualified as per clause 2.6.2 of the request of proposal, and the bid security shall be appropriated accordingly as specified in this clause. Consequently, the bidder is considered technically non-responsive.
Is that letter on record?
Lordship,
Is
that
that-
letters are not on record because it's the internal communication. It was never given to me. Now, my lord would find the works. Actually, they had given 3, my lord. Actually, there are 4. I have said there is 4 works, which I have not disclosed, which I could not have disclosed. That, my lord, would find at page 142.
Where do you get this 3 and 4?
My lord, that we have got the information from the authorities, my lord, on inquiry.
Okay,
And I have said that in my petition also, madam.
okay. Yes, now which page?
Page 142. My lord would see this is a work allotted to Matlebuddin Ahmed, who is the petition number 2, my lord. Then 143, it goes on till 145. Now what has happened, my lord? These are all, my lord will only note one thing, 142, 130. These are all chief engineer PWD border roads, PWD roads. Now my lord would come to, I'll just trouble my lord to the initial part of the documents, my lord. My lord may have page 34.
This is 142 to 145.
142, 145. These were the works, my lord, which were not assigned, which were with the petition number 2, but not assigned to the company.
Yes.
Now, my lord, page 34. My lord, this is an order passed by PWD NH Works. Each of these are different organizations, my lord.
Yeah, 34.
34, my lord.
Yes.
My lord, this is one order passed. The registration of Matlabuddin Ahmed house number so and so for the year and subsequently renewed is hereby cancelled on the basis of application affidavit submitted by the contractor with immediate effect. Henceforth, the registration certificate of Solna will not be eligible for submitting bids tenders for any works with the above registration so in APW NH wings in future. So it's particular to that. Now, my lord will see the second paragraph. Consequent upon change of the registration of all works under this department in the name of is to be transferred in the name of Purbanchal Biltic Private Limited house number for all purpose. Now onwards, Purbanchal Biltic shall be liable to accept all risk and responsibility for all works and other outstanding liabilities of Matlabuddin Ahmed under Assam PWD NH wings. Now, my lord, similar order of the border wings is now there. Border wings is continuing to have the work done by Matlabuddin and payments are being made to him. These other works, which came around 17 works were there, which came to us, the company, the petition number 1, my lord, this we disclosed. Now, they say, because you have not done it, you are out. So, my lord, this is the first case. And with regard to the respondent number 6, my lord, I have raised a plea that there is a requirement in the contract, in the NIT itself, that any certificate, because certification has to be made by the CA, my lord, here. Any certificate issued by the CA should have a unique document identification number. And my lord, this is a number which should be there for different for each and every certificate. What he has done, my lord, they have taken out one certificate number and issued continuously, my lord, 4, 5, 6 certificates, which as per the, my lord, documents which we could lay on our hand is not permissible. Then, my lord, there is a second UDI number taken for a work which is in Digaru. Sonapur Digaru, my lord. But the work has been certified.
No, supposing, let
Lordship.
me understand what you are proposing.
Lordship.
Let us say that the PWD, we forget PWD, let us say irrigation department, for example, has floated 3 tenders.
Lordship.
In 3 tenders, same set of documents are required to be given.
Lordship.
Now the CA certificate containing that unique documentation number, you say for all 3 contracts, separate numbers are to be allotted.
Did not be, my lord. But for the each and every different works, because he'll be giving certificate for different works. Say I have done work A, road B, road C, road D. For road A, there will be a certificate that I have received so much.
That's what I'm saying.
For that only, but no need. Only that road A, road B, road C, road D, there should be 4 UDI numbers.
4 unique numbers. So therefore,
that can be used across the board, my lord, in any tender. That can be used in various tenders, my lord, during that period, whenever that validity is there.
So therefore, let us say, for clarity, let us say one document is a profit and loss account.
Lordship.
Second document, which is actually a part of balance sheet, is the balance sheet itself.
Lordship.
Your profit and loss account is a part of balance sheet.
Lordship.
Now, we take it that these are 2 documents and therefore there are 2 unique numbers given for these 2 documents. Third document, let us say, is a CA certificate itself.
Hmm.
So 3 documents are there. One document is marked as number 1, one is 2, one is 3.
Three.
Now, in respect of 3 tenders, same 1 to 3 will do, or it will be 1 to 3 in one,
You
second
say
it will
if
be
it is
4, 5,
issued-
6.
These tenders are issued during that period of time, same period or simultaneously. My lord, the documents would be practically the same.
Same.
So this would do, my lord.
Okay.
This would do. But what is required here, you can't have one UDIN number for all these 3 documents.
3 documents.
You
Okay.
must have 3 UDIN numbers.
Okay. Okay.
And here what has happened, they are giving the respond number 6 CA is giving certificates for different works.
Where is that?
My lord would have it at page 146, my lord.
Yes.
My lord, the UDN downloading number is, my lord, first at page 146. My lord would find in the middle, unique document identification number,
6310, last number.
6310, D6310.
Yes.
The first number has been now, my lord, incorporated 147, page 147, which is for a work in Dibrugarh, my lord.
No.
Right, certifying about a work amount
From
received.
this document, what do I understand? What is the document referred to? And
My lord,
it is
the
for which
document
work?
is the capital cost or the amount received against a particular work by the contractor. My lord, we'll just read it. The second paragraph. We further certified that total estimated capital cost of the project is rupees 10.81 crores. My lord has got it.
Hmm.
Of which the applicant received or has executed work as certified by the engineering so and so, rupees 10 point crores.
No. I've not understood. This annexure H page 146 is a pre-page to 147.
No, is a post page to 147. Oh, sorry, 146 is pre-page to 1.
Pre-page to 147.
147.
Okay.
And that number has been issued here, UDI number just above the signature of the, my lord, the chartered accountant down below. Left hand
Okay.
side, above that UDI
I am
number.
not
my lord.
drifting, my friend. After that, there is a subsequent notification of 2022. My friend is referring to 2019. In the 2022, this was a frequently asked question, and the Institute of Chartered Accountant has clarified that for one assignment, you can use the.
I have brought it, I'm
I-
showing, my lord. I brought that on.
Let him complete his
I
part.
have brought
Otherwise,
that
I'll
on record.
I'll
I
be
brought
confused.
that up.
That's why I didn't interrupt.
My lord would have 148.
Hmm.
This is a particular work, say in Dibrugarh NH, the first one 147. The next one, my lord, is again in Tinsukia. Same UDIN number. Similarly, my lord, till 140, 50, 151, 52, 55. Till 55, my lord, this goes on. Same UDIN number, but all these documents have been issued. Now, my lord will see the beauty. 156.
146 to
155. The number in 146 has been used.
yes.
Now, my lord will come to 156.
156.
56, my lord. Here the UDIN number is 8711. My lord has got it. Now, why this certificate, why this UDIN number was generated? That my lord would find in bottom figures and particulars.
Yes.
Certification come undertaking, river training work for Digaru Bridge at Chainage so and so of NH 13. Certification come undertaking river training work of Digaru Bridge at Chainage so and so. So for this, my lord, this was generated. Now, my lord will see the certificate at page 157. It's for some work at Digaru. My lord will see at 157. Based on
Yes.
books of account and other published authenticated by it, this is to certify that Mr. Sanjay Kumar Singh, name of the was engaged by Chief Engineer PWD Boats Assam Chanmari to execute construction of road from Hulung to Gutibari to Betoni, length so and so, including cross drainage and routine maintenance works for 5 years under so and so district, Tinsukia package number so and so. batch number 3. So what certificate was issued for, my lord, Digaru project is now being used for Tinsukia. Now what my senior friend has said, my lord, that my lord would find at page 159 onwards. That is the, my lord, clarifications given. My lord will have page 162. My lord will have question number 32 at the top, my lord. What is meant by document description? My lord, under document description, the details of the document for which the UDI number is being generated are to be filled in 15 to 50 characters only. So each document. Now, my lord will come further to 163, my lord.
No, this I'm not being able to.
My lord, it says
Under
that
document description, the details of the document for which
Document.
the UDIN
lordship.
is being generated are to be filled in 15 to 50 characters.
Characters. So what the document is, I'm only trying to say, my lord, for a particular document, they do it, then they upload that document with the particulars that we want a UDI number against this document certification. So they issue it. So for every document they issue, my lord, there has to be an UDI number. I'll clarify that at page 163, my lord, that will be clarified. Page question number 39, madam. Whether one UDIN can be used for multiple certificates generated on the same day. My lord, here my lord would find the certificates from page 147 onwards were generated on the same day. No, separate UDIN is required for each assignment and is to be used for all documents issued under that assignment. So here the assignment, my lord, will be the work. And my lord would have 40, whether in bulk UDN can be generated. They say you can generate it in UDN. But that's, my lord, I'll have to clear my part first, then his comes first. This is one for. Now, my lord has seen, because the works for which were never assigned to the company, petition number 1 company, I cannot disclose those works, my lord, because it's being already continued by the petition number 2 and the payment. That's it. So, my lord, that rejection in that case is bad. Now, my lord will come to the second case, my lord. Here, my lord will have page 45. My lord, here the work is in, my lord, Abhaipuri division. Work cost is 10.51 crores. Completion period is 180 days.
Which page you are referring
Page
to?
45. Page 45. My lord has got it.
Yes.
My lord, it's 180 days. And my lord, that unique documentation number, well, that permission is NB. That is good. My lord may ignore that for that, because my lord has already seen it. Now the minutes, my lord would find at 146. It starts at 146. The relevant would be 148. my lord, the first ground is similar to the first case one. That I did not disclose the works.
Yes.
I'll not trouble my lord with that. I'll only have my lord's attention to the last 3 lines of the first paragraph. Purvanchal. My lord, from the right hand side, my lord, the word starts with the word also. Sentence with the word also, 148. Word also. 3rd line from the first paragraph. In that page. My lord has got it.
148.
148. 1, 2, 3, 4, 5, 6, 7, 8. 9th line from the bottom, top, my lord. Also.
Acha.
Also, the available bid capacity of the bidder is then less than the total required bid capacity as per clause 2.2.1, which makes him technically non-responsive. So here I have been made non-responsive on 2 counts. 1, I did not declare the works which my lord have shown. 2, I don't have the bid capacity. Now, my lord, they will have the calculation, my calculation, which is at page 154, my lord. My lord would
Yes.
have, I have given the various values, my lord. How I have got and all, complete calculation is there. A is 47.53. My lord has got it. A is 47.53. B is 45.23. The last my lord would find. N, as the work, my lord, is for 6 months, value is 0.5. On making that calculation, my lord, my bid capacity comes to 14.18 crores.
Yes.
And the bid value is 10.51 crores. Now, my lord would have that of the respondent number 5 and respondent number 6. My lord would have page 156. That is, my lord, the breakup of the respondent number 5. My lord would see he has given the value of n as 2. My lord has got it. So the value comes to 601.4774. Now the correct calculation, other parameters remaining the same, my lord would find at page 157. Here, my lord, A is 174.922 into we have given 0.05, 5 into 2.5, and the value of B is 273,174. It is negative for 54.48. But still, my lord, his bid has been held to be responsible. And whereas, my lord, I have given the correct figures, my bid has not been held to be responsive. Now, my lord, I have made categorical statements to that effect also. The works at page 155, my lord.
Which page you are referring to?
Page 155.
155.
These 2 works, my lord, of the respondent number 5. I have said that in para 14, my lord. Page 25 also. These 2 works were never disclosed. These are ongoing works. 2021 session sanctioned here. Page 155. And the corresponding statement, my lord, would find at page 25 para 14.
This is your non-disclosure.
No, the non-disclosure of respondent number 5. My non-disclosure is the works of, my lord has in the earliest is 142 to 145, my lord, the first disclosure. The statement is at para 14, page 25. So the respondent number 5, these two deficiencies were there, ignored. Now with regard to the respondent number 6, my lord, he had declared a particular number of works pending. But my lord, when we made a search at page 160, my lord, the first work was not, it's an ongoing work, not completed. This was not declared. But no action taken, they have been held to be responsible. My lord, in item number 12 and 13, the date fixed for financial bid opening was 10/7. We had approached this honorable court, my lord, during the vacations. In the first vacation court, my lord, unfortunately, the matter could not be taken up because of paucity of time. So the honorable court was pleased to fix it in the next available vacation bench with the direction not to proceed with processing of the tender. Unfortunately, in the second bench also, my lord, paucity of time, the matter could not be taken up. That is how the matter came to be listed today.
Even today, I'm thinking positive of time. No, but I'm not, I'm very miserly in extending stay.
My lord need not, my lord can finally hear the matter, but this is because I have demonstrated. If they can throw something behind that, it's a different thing altogether.
Yes, Mr. Nath.
My lord, the other two matters, same issue, but therein, my lord, my bids have been held to be non-responsive, as I have not, my lord, disclosed the works. That Matlab petition number 2's works, which when, my lord, same issue in petition in the first case, same issue is there in the other two matters in the production case. But there, the financial bids have not been opened. It is slated to be open on 21st. That means, my lord, tomorrow, day after tomorrow.
And I
But too much in the platter is also bad for health.
Not everybody, my lord. Everybody is there. My lord will see the same parties across the board in all the 4 cases. Either way.
No, I'm in the.
My friend
I'm
is only.
only in item number 12. Not in all the.
No, I was not referring to lawyer's platter.
Bidders.
I'm referring to bidder's platter.
Lordship may kindly take up the first case. Because
First.
first case.
With regard to this calculation, you have any idea?
No, that will come later. The ground of rejection of the petitioner's bid, he has been considered technically non-responsive because of, as per clause 2.6.2.
54.
I'll 2.6.2. The first lordship may kindly come to page 139, that is the my notes. 140, page 140, serial number 3 is the relevant. I'm reading serial 3, my lord. Urbanchal Buildtech Private Limited.
Just one minute.
Lordship.
Yes.
Page 140, serial number 3.
Hmm.
Urbanchal Buildtech Private Limited, based on representations received regarding the concealment of existing commitments by the bidder named Urbanchal Buildtech Private Limited, necessary clarifications were requested from the relevant head of the directorates, especially Chief Engineer PWD Border Roads through TO number so and so letter number so and so dated 25/5/2023 In response, the Chief Engineer PWD Border Roads Assam through a letter number so and so dated 26/5/23 has confirmed that the bidder did not disclose the mentioned commitments in their bid. This deliberate misrepresentation of facts renders the bidder liable to be disqualified as per clause 2.6.2 of the request for proposal. And their bid security shall be appropriated accordingly as specified in the clause. Consequently, the bidder is considered technically non-responsive. But this is the precise reason that they have not disclosed the required information and misrepresented in fact by concealing the information. Kindly come to page 61.
This clause 2.6.2.
2.6.2 and before that, Madam.
No, this page you are referring me to, you are taking me to that page.
Yes.
Is for what purpose? 2.6.2.
Yes.
2.6.2
Okay.
and Madam, under the page 53. First, Lordship may kindly come to page 53. Then Madam,
No,
page
you
62.
see, I'm just
Yes.
making a note in page
Yes,
140.
yes.
You are taking me to the other page for purpose of 2.6.2.
Yes.
Okay.
What the bidder has to disclose,
It's okay.
because misrepresentation is the ground.
Page starts at 61, 11 portion is at 62.
No. Page 60.
53 and 62.
53 and 62.
53 and 62.
53 and 62.
But 53 provides
That's fine.
the bidder.
Yeah, just
Lordship. Has your Lordship.
Just one.
Lordship.
Yes, 50.
53.
53. Yes.
But the what starts with the bidder.
Yes.
The bidder, including individual or each member of joint venture, shall give the list of projects of expressway, national highway, ISC, and EI works of Ministry of Road Transport and Highways and its implementing agencies so and so, and the status of above in each project as on the bid submission date, and undertake that they do not attract any of the above categories so and so. The bidder, including individual or any of its joint venture member, may provide 1. Details of all their ongoing projects along with updated stage of litigation, if so, against the authority government. 2. The details of updated ongoing projects of blacklisting so and so, details of all of their ongoing projects in the format at NHA 8 appendix to so and so. The authority reserves the right to reject an otherwise eligible bidder on the basis of the information provided under this clause 2.1.14. The decision of the authority in this case shall be final. Then Lordship may kindly come to the other clause at page 62, 2.6.2. The authority reserves the right to reject any bid and appropriate the bid security if at any time a material misrepresentation is made or uncovered.
Yes.
And B provides that the bidder does not provide within the time specified by the authority the supplemental information sought by the authority for evaluation of bid. But this at any time a material misrepresentation is made or uncovered, this ultimately result that the authority can reject the bid of the bidder and they can appropriate the bid security. But I have received an information, some instruction from the authority. I'm placing it up. one document. Right? In fact, Mullah, this particular document has a reference at page 34. So 34, Mullah, the learned senior has already read. Lordship, I have flag marked the affidavit. Lord. This is the affidavit given by him before the authority. Lord.
In this time.
May I read, Lord? No, read it. Oh, one second. Followed by this affidavit, Lord. This affidavit states that I, Muhammad so and so, son of so and so, by profession so and so, solemnly affirm and declare as under that I am a citizen of India by birth and permanent resident of the aforesaid locality, that I am a class 1A contractor of roads, highway works for government and government of Assam PWD, registered as sole proprietor of so and so, that consequent upon the growth of my business during the last couple of years, I, for the purpose of better management of my business, have formed a company under the name and style as so and so, PAN number is mentioned, which has since been incorporated under the Companies Act 2013 as per the certificate of incorporation issued on 2/6/2022, having its registered office as so and so. Then next page. Consequent upon the formation of the said company, all my credentials, technical, financial, experimental, managerial, and whatsoever other so forth from this first day of August 2022 may be counted for the company Purvanchal Buildtech Private Limited for all purpose of fresh bids and contracts for supply and construction works for roads, highways, bridges, and all other types of construction works under Assam PWD roads, Assam PWD building, Assam PWD NH, National Highway Authority of India, and so all the authorities he has mentioned.
Have you read
And-
this old classic case of Solomon and Solomon? You don't remember it? Okay. So that is the first adjudication, which says that a shareholder is different from a company.
But kindly see the affidavit
No, no, you
undertaken
see,
given to the
there is
authorities.
a reason for it,
Lord.
for my referring to this Solomon and
Lord.
Solomon. Now you see, let us take an example which may be inappropriate, but it's still an example.
Lord.
Correct. X is a lawyer. Today in a matter, he engages Y as a senior and does the matter. Tomorrow, and he says, he gives a what you call undertaking in the form, saying that in this case, he has engaged Y as a senior. That is a declaration on record. Tomorrow, he stands opposite to X in a different matter. So that declaration given in the earlier proceeding, saying that he has engaged X as Y as a senior, is not a valid document for the purpose of a next rate petition.
Correct.
Correct. This is a unique feature of our lawyer community.
Gotcha.
Now, this is one example. It may be inappropriate, but I'm just referring to it. Now, assignment is not a one-way traffic. The PWD X opens a company. He says that work to me is assigned to the company Y. Now, please tell me, is there any rule or any act which says that once a declaration is made, the PW is bound by it?
No, I have two submissions. Lord.
No, no, I'm still not finished.
Logic.
The Assam PWD for one purpose accepts his contention and gives him that assignment. That all the works of the petitioner number 2 would now stand assigned to the petitioner number 1. Correct. But what happens if the CPWD does not do it?
They may not.
They may not do it. Now the question is that if unless the assignment is made, can there be a presumption that the work which is being done under the PWD has actually been assigned?
But the purpose here is to see his bid capacity.
No, I understand.
Ultimate matlab the
No, I
money.
understand, but you see,
Logic.
if he gives a declaration
Logic.
without the CPWD accepting the assignment, now supposing take a reverse case where the petitioner gives a declaration that this work is my work, and that is found to be untrue, then what happens? Then you say that no, this is a case, this is a contract of this, what is the name, Maktibuddin Ahmed, which is the assignment has not been accepted and therefore is a false declaration.
That is another aspect of the matter. But
May I interrupt? It is not only the.
No, I'll come back to you.
It is
but
not only
because,
the affidavit.
there's a
There
thought
is a
process.
statutory declaration by him also.
No, that is a thought process going
Yes.
on.
I have
Logic.
taken note of the.
Logic. Malad may also kindly see, just let me read the next paragraph also.
Yes.
Logic. That with the formation of the new company in the nature and in the name and style of so and so, other than ongoing works in the hand of so and so, fresh bid shall be tendered in future in the name of newly incorporated company so and so. But in fact, by this, the next knowledge that all my existing assets and liabilities along with loans, working capital limit, equipments, finance, vehicle loan, or any other will be transferred to the newly incorporated company Purvanchal Builtel.
Very hard to accept. See, I'll tell you why.
Logic.
It's a very simple way to explain it to you.
Logic.
You avail a car loan. Supposing today you want to buy a Mercedes, you want to avail a car loan. Say, value of Mercedes is 1 crore rupees. You want 1 lakh rupees as car loan for that Mercedes. Correct. Now, it is easy for you to say, give a declaration that from today onwards, the loan availed will be paid by the company. But will the bank accept it? Assignment of a loan. There's a decision of this court in the case of Frontier Construction Company, where assignment of liability was rejected by this court. You will know of this case. I'll tell you
Yes.
the example. What had happened was Bharat Hydroelectric Corporation came into existence. And AACB said that from today onwards, the liabilities of the liability of AACB against Frontier Construction Company will henceforth be paid by this Bharat Hydro Power Corporation. They came to this court. And this court declared that assignment of liability cannot be accepted ex parte.
Correct.
Because the party does not contend. I know that I can't extract money from Mr. Kumar.
Logic.
Correct. So if you say that assign the liability to Mr. Kumar, I may not accept it. I know I can't deal with him, but looking at your structure, I think that no, if I claim with Mr. Nath, maybe he will buckle to my pressure and he'll give me my payment. So it is on the lender to say that from whom he wants to collect, because I did not give loan to Mr. Kumar. I gave it to you. Bank says that no, I gave it to Mr. Nath.
Logic.
So therefore, your proposition made in a self-declaration that can't be a law being created for by the party.
Gotcha.
It's a self-declaration. This declaration PWD may accept, may not accept. What happens if the PWD doesn't accept it? He says that no, I won't assign it to the company because their capacity I don't know. Let us say a high value contract.
Gotcha.
You say that, well, your assessment we have done when we gave you the work, but this company is a new entity. Like, for example, you say, we give an example of the company. A company has a limited liability to the extent of the shares alone.
Shares.
Now, this solvent company, what happened was, he floated a company with a limited shareholder, and then he says that, no, I can't have the capacity to pay. So whatever is the share money, you take it. So it was a 10 rupee share for 7 persons in their 9 persons in their own family. He declared himself to be insolvent. That the company value is worth 90 rupees, you take whatever you want, and then we are not paying you.
Well, it was the first case where the doctrine of lifting of the corporate veil, whether the company is liable beyond the share value of the company and whether the company is illegal.
I'm
entity.
giving an example to Mr. Nath.
Lordship.
Because you see, so therefore what happens was that CBWD or that company, that unit did not accept the assignment. Well, it changes the equation.
Correct.
You assess a capacity of X and then transfer it to Y.
Here,
So therefore-
NHPWD had, roads had accepted.
No,
Water
whatever
wings
we-
have not
I'm not on that.
Lordship.
I'm not on the specifics.
Malad, under this, this facts and circumstances, Malad, it was considered. Malad,
No, because you see, Mr. Nath, I'm putting this question to you for a reason.
Malad,
The question which I'm proposing to you is
Lordship.
whether there can be an assignment without actual assignment being accepted by the CBWD or something,
that
PWD,
particular PWD road,
PWD roads,
border roads.
having border roads, having not accepted the assignment, can you still disqualify the petitioner?
Malad, I'll come up with the instructions, Malad. This has come for the motion. I got because it was moved in the vacation bench. I got this little bit of instructions I got.
You take it up on Friday
Lordship.
in the motion matter, because
Yes,
this is, I'll just hear Mr.
Yes,
Kumar, so that on the next day I don't have to take so much of trouble of hearing.
Yes.
Yes, what do you have to say in that? Oh, and in the second part,
Yes,
with regard to his, that calculation of value two,
Malad,
bid capacity, that also you take instruction, you
Yes,
note
yes.
it down.
as regard bid capacity, I don't have the instruction. I have to take it. I have
You take that.
Lordship.
And there is a third question also,
Lordship.
which Mr. Nair has shown. In the chart which he has given, which I will not remember that chart.
Yes,
He says that 4 or 5 works, the respondent,
in the
private
second
respondent did
case.
not disclose.
Not
In a second
not
case.
the Mr. Cohn's client. Those are different.
Those are
respondents,
different persons.
Different
Okay.
But same.
In the second case, that I have to take instruction.
That also-
Second,
Yes.
third, fourth, all.
3 instructions you will be required.
Yes, yes.
Yes, Mr. Kumar.
Mhm.
Well, along with the bid document, the memorandum of association of the company was also uploaded. That memorandum of association is not part of the writ petition. I have a copy which was downloaded because that was uploaded in the website.
Certificate of incorporation.
Not the certificate, the memorandum of association, how the company will deal with the outside people, unlike the article of association. 11 clause. It is an admitted fact that so far the 3 works have been concerned, it has not been disclosed in the bid document. Now you also will see, this memorandum was. This memorandum came into being in 1st of August 2022. You also will see clause 3 at the top. Further, all the credentials, technical, financial, experimental, managerial, and whatsoever others so forth from this 1st of August 2022 of Mohammad Matlebi Ahmed may be counted for the company Purbanchal Buildtech Private Limited for all purposes of freights, bids, and contract for supply and construction of work for roads,
Mr. Kumar,
highways. Yes.
Is the same question to you in a different structure?
Yes, Malak, I'll
You
come.
see, my question would be to you now. A self-serving statement. Does it create any legal obligation?
Malad, along with the bid document, Malad, there was a CS certificate to the effect. That is also not part of it. I can read it, Malad. Your Lordship will hear the content, but this is the CS certificate. That's a copy.
Because you see, the answers are, the,
And this has
you
been.
see,
this
I'll tell you, before you start, let me say that. You see, what happens is, in the Supreme Court of India, the procedure of practice is that once you have a certain amount of appearances made, then you are considered eligible to become a member of the Supreme Court Bar Association.
No, my lord,
Let me finish. I may be wrong.
Yes.
It's only an example.
Yes.
So, for the purpose of number of appearances, I have seen with experience that if I write as a judge, if I am writing Mr. B.D. Kumar, the lawyer will give, say, Lordship, I have given a slip. You would not like your name to be recorded as B.D. Kumar, you will require it to be written as Bhaskar Dev Kumar. Because of the purpose that because you see, Mr. B.D. Kumar may be 100. For example, let us take a name of Mr. A. Sharma. In this court, maybe we have 10 A. Sharma.
Yes.
So therefore, which A. Sharma's appearance is being recorded is unknown. Therefore, at times, lawyers insist that my full name be recorded. Otherwise, they have a issue that his appearance is not being recorded, and therefore he can't claim benefit of that. Let us say it's an example. I may be wrong, horribly wrong.
Now, let me correct it, my lord. Now, the system in the Supreme Court is that appearance, full name and all, you can upload it in the system at 10:25 or 10:15.
No, that's what I'm saying. I may be wrong.
Yes.
We will assume that I am wrong.
And this.
But it's only an example, illustrative purpose.
Yes.
I am saying that therefore recording of even a name may be incorrect in the context. Correct. Now, the question is that if an assignment is not accepted by the principal, like Mr. Nair has said, that which border roads did not accept it. Now you see, irrespective of all the declarations made, when you write your name B.D. Kumar, Guwahati University doesn't acknowledge you because in their certificate they have written the full name. So if I give an RTI application asking a statement as to whether in Guwahati University has ever given a pass certificate to Mr. B.D. Kumar, there is every likelihood that the answer would be negative. So therefore, I have to pose a correct question that whether Mr. Bhaskar Dev Kumar has acquired any certificate from you, and then they will say yes or no. Correct. If I pose a wrong question, I'll get a wrong answer. So with this background, now you please continue.
Even in case of artificial intelligence, you will get the response to how you structure your question.
You have seen today's newspaper.
My lord, which news your lordship is referring to?
In today's newspaper, which paper? Don't ask me. Because I subscribe to 3, which where I have read, I don't know. Now this AI has started to recognize facial expressions, but it has still not been allowed to come into the public domain because this AI has developed a habit of giving comments on the name, on the face. Supposing you are having a smiling face, they may say smiley, which may be offensive to you. So it's an artificial intelligence. They have grown more intelligent than what has been fed to them. They are now recognizing today's newspaper, you will find, either in the Assam Tribune or in the Times of India, where it says that the artificial intelligence have gone to that extent, but it is still not in public domain because it has started to give its own interpretation to a facial expression.
No, my lord, your lordship probably has seen this time in T3 in the Delhi airport. They have now this Digi Yatra. You don't have to stand in the queue. You just stand in the front of the machine. Your facial is recognized, and then no queue. Up to the security check, you can go.
I am on. That's beside the point. That is not the issue. What I am trying to say is that, you see, the question is, moot question is assignment. If the assignment you don't accept,
the liability.
No, assignment.
Yes.
First is that work of A.
Well, that because my friend has referred to 37, page 37, I'll come to that. But before that, your lordship will see this was filed with the Register of Companies also.
Yes.
I have shown your lordship the memorandum of association, how Matlabuddin has merged with the company. And this is the certificate where they have taken up the liabilities and they have inform the register of companies, my lord.
Same
So-
question which I give to
Yes.
Mr.
So-
Mr. Nath, you see.
And in case of that document,
No,
my lord,
you
which
see,
you-
now Mr. Nath, for that 1 lakh rupees loan, unlikely that he will take it. But it was only an example. 1 lakh rupees, he declares in his own, all the documents in the certificate of incorporation that the company will pay.
Yes, ma'am.
Is the bank bound by it?
The bank will look into the memorandum of association, the clause and this
So unless-
certificate, if he has filed it with the register. Then,
unless-
just like in the case of society, if the society bylaws provides that the liability will be taken by the society or the bank account will be opened whether in a nationalized bank or in a local cooperative bank. If it in the bylaws, it is said
No, no.
nationalized bank, that the cooperative bank will not
Once the
accept.
bank gives a loan, they will be the only one to decide from whom they will return the loan. The example of Frontier Construction Company, I've already given it to you.
So, my lord, here, my lord, your lordship's query probably has come up because of that page 37.
No,
my lord.
no, it's not that. You see, irrespective of whatever declaration you give,
Hmm.
unless the principal, that is the border roads, accepts it, can I give a declaration that my credentials is same as that?
No,
Because
no,
the principal has
No,
not taken it.
my lord, so far PWD is concerned, where the work is concerned, they have said irrespective of any work in any organization, it doesn't say of a particular organization. Your lordship will first see how that came into being, my lord. Your lordship will first see page number 34. How they have changed it, my lord. Page 34. All the works are in the name of the in the name of Matlabuddin. It is not page 34. Your lordship will see.
That is specific to.
Yes.
And it's-
Is hereby cancelled on the basis of application and affidavit submitted by the contractor. In this case, he has not bothered to file the affidavit and the and this application, my lord. And if your lordship looks into the NIT itself, this is 95. Page 95, your lordship looks it again. Page 95, this third paragraph, my lord. The statement showing the value of all existing commitments, anticipated value of work to be completed in the period of construction of the project for which the bid is invited, and ongoing works as well as the stipulated period of completion remaining for each of the works mentioned above is verified from the certificate which is so and so, so and so. Why this is required? Because if your lordship has taken note of that formula. So if in that formula, my lord, it be the ongoing work value becomes more, then the bid, then he will not fulfill the bid capacity of this contract. Here, the bid capacity of the contract is 7.5 crores and the undisclosed work was 26 crores. That formula he will not satisfy. That's why there is a reason behind why this has not been disclosed, my lord. That is number one. Second, my lord, in case of this type of nature, my lord, he has said that my UDIN is not valid. Your lordship will see in respect of the UDIN, my lord, my chartered accountant has given a clarification because he is referring to the notification of 2019. And even the frequently asked query is prior to 2020-22. The CA has clarified, my lord, your lordship will kindly look into that document. For one UDN, my lord, for one assignment, the CA on the one date has given this 1 to 11. For the rest, he has given different UDN. And the question, my lord, is that question number. You'll also read from the first page itself, my lord.
judgment. to the
Okay,
So UDN, that my lord, that ground will not hold so far we are concerned that that is within the permissible statutory requirement. If they-
just give a copy of this to Mr.
Yes, I have given. And the that frequently asked queries of 2022.
Okay. We'll take it up day after tomorrow in the motion column.
But the only prepare is that, my lord, your lordship, since on the other day, my lord, when the matter was not heard, it was only due to the paucity of time the interim order was passed. My lord, I will pray that this interim order will not be extended till.
No, for 2 days, nothing will happen.
My lord, how can, because now my lord.
Because once the order is there, it has been continued. But I'll have to just write two things, 2 lines and then.
My lord, only thing is that production list, those two matters. The financial bits will be opened on 21st.
On 21st. 21st, we are taking it up.
Lordship.
21st, we are
My lord,
taking.
your lordship will kindly take up tomorrow in the second half, my lord.
No, it's not possible because tomorrow fixed matters are there and tomorrow there's a very least chance of any other matter being taken up because we are taking up what you call out of turn matters. Top of the list matters will come.
Then, my lord, on 21st, your lordship may take it up at 2, my lord.
No, 2, my lord, the financial bits will open. So, my lord, it may be difficult. So, my lord will direct them till the next date. My lord, they will not open till the conclusion of the process. That much, my lord, can do.
Okay, let me pass an order. This, there are 4 matters.
My lord, then may I pray, my lord, subject to the convenience.
No, in fact, we have already heard. It is only
my lord,
the 3 queries which are required to be answered by Mr. Nath.
My lord, I would like to address further your lordship, my lord. Subject to, because 21, I have some prior commitment, my lord. May I pray, my lord, that subject to your lordship, let this matter come up on 26th then. Let the infrastructure.
No, you see, high value tenders are at stake.
That's why the Supreme Court has said that no stay in time order.
That's why, but once a stay has been granted, we are bound to conclude it.
Those stays were, those stays were not.
You give a written note of whatever you want to add, bullet points you can give. Because basically, the idea was to hear it just to shorten the proceedings on 21st. So that's why I'm hearing, I put my queries. These are the 3 points taken by him and 3.
Yes, your lordship then will give a return. Your lordship will kindly formulate the queries, then it will be easier for us to reply, my lord.
It's already done.
No, I've already told him.
Let it be reflected in the order.
No, I'm not reflecting because then I'll be bound by what I've dictated. I have a tendency to go astray. I'm not binding myself at any cost. In tender matters, I'm not binding myself. What will come out tomorrow from the closet, we don't know. I'm not binding myself.
Only then it would have been easier for us to respond in my absence, my lord.
No, you see, Mr. Kumar,
The arguments can always be formulated.
what you call the essence of whatever my queries, I have given it right now. But tomorrow, what will be the queries? I don't know. Therefore, I'm not binding myself. When I have not heard it completely, I'm not. Had this argument been concluded, then it was a different matter.
Then may I pray, my lord, that on 21st at 2, your lordship will take it online. So far, I am concerned, my lord, if it's possible, my lord.
Then, my lord, will only protect me to that extent that the bids will.
It's okay. 21st will take care of 21st.
Because what happens, my lord, is that they will only open for the.
Mr. Nath is there.
My lord, because there is a problem, my lord. Because once the technical financial bids are open, it will be open for the responsive bids. Once that stage is over, my lord, the other bids will be vanished. You cannot go back. My bids cannot be retrieved thereafter, my lord. That's the only problem.
I'll tell them not to open till
The conclusion of the year. Enough. That much will do. That much will do. That much will do. That much will do. That much will do.
This is better than an undertaking. Nuts.
Mr. Nath, I value his statement.
More than enough.
More than enough.
It's not one day association with us. Correct.
Once Mr. Nath says there should not be any doubt.
So not only that, but
Only I had some, because your lordship again is right, because in those judgment of the Supreme Court, so far road infrastructure is concerned, It's not a question of one individual, the larger public
No,
interest
once-
is in
once-
the
once-
government.
once there is a
Just
palpable
let me pass
illegality.
an order because I
Lordship.
won't go into those things.
Lordship.
I'm aware of 41A, so don't worry about that.
This was
Ah.
very important. Lordship has taken care of that. That is why the matters is out there.
No, that is why I'm hearing it.
That's why I'm also reluctant in taking a judge.
Uh, This item number,
12,
the first two motion matters, item
12, 13
12, 13.
and production list 1 and 2.
Heard Mr. UK Nair, Senior Counsel, assisted by Mr.
8 Chakraborty.
A. Chakravarti, counsel for the petitioners. Also Mr. D. Nath. You will record you as standing counsel for PWD. Appearing for respondent numbers 1 to
My lord, it would be the first case. 1 to 4.
1 to 4. 1 and 2 are same.
Yes.
Second is also same.
No,
1 to 4
NH works, PWD borders, my lord, 3. Different, my lord.
is different.
Different.
Achha,
1,
so
2, 3.
Write separate
4.
orders then.
1, 2, 3,
No,
4.
Just a moment. Write separate orders. Item number 12 first.
12.
12 will be 1 to 4, Mr. Nath.
1, 2, 3, 4.
Same, my lord.
1 to 4.
Yes,
Huh.
yes.
And Mr. B.D. Kumar, Learned Senior Counsel, assisted by Mr. H. Agarwal, Counsel for respondent number
5.
5. Next para. The submissions of the learned senior counsel of the council for the appearing parties are almost concluded. Mr. D. Nath Leonard, standing counsel for BWD, seeks some time to obtain clarification. Was particularly list on 21/7/2023 in the motion column. Next, for interim order passed earlier stands extended till the next date of listing. It is made clear that interim order passed earlier shall be revisited on the next date. And then this item 2, you will write Mr. Nath is now number
1 to 4, my lord.
same.
Same.
In this item 13 also same. Then production list number 1.
1.
What is the status?
My lord, it would be respondent number 1 to 4.
1 to 4.
Same.
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 So, same. Here there is no interim order.
No
Item
interim.
supplementary supplementary list 1 and 2. There is no interim order. And supplementary item 2 is also same. No interim order, huh? No extension. Okay.
Come on, by some
We give you
motion.
liberty, just move the registry, will permit your online hearing.
It is, online number. Much obliged.
These two documents, shall I keep it here?
My lord, can keep it on record. Let me get it.
This CA certificate and certificate of incorporation which you have given.
In online, only the facial expression and the eye contact is accepted.
Facial expression can be disabled.
You can, we can give you liberty subject to approval of Mr. Nath and Mr. Nair. We give you the liberty to ask to your junior to give us your photograph.
Give me online.
Yes. Item 14. I posed a query. I
Got it.
hope you are aware of that.
Yes, Well, the Lordship, as regard the regular tender process, my lord. The regular tender process, my lordship. But I have got the information, my lord. In fact, I'm guessing.
There, in fact, what has happened is that there are 2 or 3 group fisheries
Yes, yes.
where with the amount of litigations which are coming up, I'm compelled to take a harsh
Correct.
view in the matter.
Correct. my lord. In fact, after a lot of persuasion, my lord, a judgment has come that within 3 months, the regular settlement has to be given. But now the position is, my lord, the deputy commissioner has already demarcated, kindly para 3 may be similar. 17th of July 23 letter. The para 3, second paragraph, sub-paragraph. The boundary of Dibru Brahmaputra and Brahmaputra part 3 has been defined on 31/5/2023 and proposal submitted to the government for notification of the fishery boundaries by letter number so and so. Copy of the minute and the letter are annexed, minutes I have given. But now they have sent the matter to the revenue department for notification. The boundary will be notified and immediately this will be done. But as regard the judgment of the honorable court, because the time limit has been given, but we have been instructed to pray for some extension of, we are preparing it, we are going to file it. Otherwise, the demarcation has been done. This will be done. They have said within 3 months they will do.
No, you see,
Lordship.
so far as the court is concerned on the judicial side,
My lord.
we can take note of your what you call this proposed boundary,
My lord.
and we can still subject your application being moved. We can always give you liberty to go ahead with your proposed tender, because once there is a delay, we take it that it is an intentional way to what you call
Give benefit to some of the.
no, I am not on that.
Lordship.
To disobey the order of the court.
No, that is not the intention at all, my lord. That is not the intention. My lord, in fact, on 31st.
No motives. I am not attributing any motives.
Lordship.
Insofar as the court order is concerned, I am to implement that order.
Correct.
So therefore, I can. I am using a spectacles to only see that the orders of the court are being implemented. Because in this, one is this fishery.
Correct.
Second is that Dhubri fishery. What is the name?
My lord, that Dhar Brahmaputra or something like.
Oh, whatever. Yes, these 2 fisheries we have to.
Correct. Lot of litigations are there.
A lot of litigations are there.
Well,
And few of the parties are very, very prominent in these litigations.
correct. In fact, my lord, the on 31st of May 23, this has been done. Committee has been constituted, lordship, in that only, my lord, lordship, the annexes are there. So now the matter has been sent to the authority, my lord.
Okay.
Lordship.
Okay.
My lord, that is my.
So you have been able to successfully thwart the what you call notice at this stage.
As
Yes.
regard the merit of this case, my lord, I'm not making any submissions at this stage.
No, it's okay.
Lordship.
I look- See, my lord, what lordship can we have a look at page 90 is the European order.
Page
Page 90, my lord.
90.
90. Operative part lordship can see at page 91.
No, but there's something you'll have to answer. The allegations being made by the learned counsel for the petitioner,
My lord.
is that the bidder is a defaulter?
From
So
the
that
report.
Mr. Datta is saying that the remission prayer has been made and therefore he's not a defaulter.
In fact, this honorable court, my lord, has in fact interpreted that. I'll have to show that.
No, it's okay. I'll come back to you when the
Yeah.
turn comes.
Lordship.
So therefore, this stand you'll have to take.
My lord, so far the challenge to this.
No,
order-
that will not, let him complete his
Lordship,
first.
lordship.
Then you have to take that.
Well.
In the meantime, you can get instructions on that.
Right.
Because that is he says that the Mr. Datta is a defaulter.
Lordship.
Yes.
Lordship can see from the order, my lord, that whether he is defaulter or not.
No,
my lord.
first of it, you say under the fisheries rules, is that default, what you call,
Defaulter, my lord, he has
impediment?
no right to even to participate also.
Where is that? Which rule?
Participate also there, my lord.
Which rule?
He has to, it basically deals with rule 12, my lord.
Rule 12.
Rule 12. Jadi rule to ano na. There has to be two specs, my lord, one Bakijay clearance and one, my lord, no revenue is payable by the any lessee to the government.
No, which rule? I am reading rule 12. I don't find that defaulter is not entitled to bid for fishery.
Is there, my lord, because of the terms and condition of the every need is there, my lord.
No, that I don't know. You see, terms
have
and
to-
conditions and the rules are, under the rules, you have to show that a defaulter is not permitted to, for his bid to be accepted.
Yes, my lord. At that point, I'll clear, my lord. Lordship, kindly have a look, page 72, my lord. Page 72 of my writ petition.
We are giving you that rule. In rule 12, it is not there.
It's my checking, my letter.
Hmm.
Is the defaulter list, look at the picture, my lord.
Yes.
By this time, I'll let him check up. By this time, I'll clarify the position of the case, my lord.
Yes,
Lordship,
yes.
kindly turn to page 72.
I'm there at page 72.
72, my lord, Roman 4 said, my lord, he is a defaulter of 64 lakhs 98,000. And he has given, my lord, 15 days time for the representation to government to take decision thereof. Whether he is entitled for the remission or otherwise, my lord. If it is not done within 10 days, my lord, that is, he will be treated as defaulter and can be seen page 73. So now the core issue is that, my lord, since he is declared as a defaulter, once defaulter, my lord, the moment he has been given temporary settlement, despite the fact that, my lord, being a defaulter, meaning thereby, my lord, his defaulter has been revived, my lord. For that, my lord, he is not entitled for any kind of settlement, whether temporary or regular settlement. On the earlier occasion, lordship has seen the last case, my lord, 391 given to the somebody else. We offered 4,600, which was not considered to us, my lord. Meaning thereby, my lord, they are pinpointing to some particular interested person. I offered 51 lakhs, that has not been given, and given to the person who is a defaulter, and that effect, my lord, totally silent in the impine order. So in that view of the matter, my lord, if once a defaulter, he has no right, my lord, that point I'll clarify. So in that case, my lord, his settlement has to be stayed, my lord. Then government let them come and clarify, or private respondent clarify, there is no outstanding liability at the date of taking settlement. That will end everything, my lord.
No. You see, there are certain things I find it very difficult to accept. And the reason is that since I come from the east side of this building, I find it very difficult. You see, you have taken a car loan,
Lordship.
correct? And you are making a repayment timely. You are not a defaulter. You may be you may have a liability, but you are not a defaulter.
But here is the case, finding of the honorable court was the
No,
finding.
that's okay.
Defaulter,
Let it be clarified. So therefore, being a
Honorable court
defaulter,
found
being
being
a
a
defaulter
defaulter.
and having a liability are two different things. Yes, Mr. Nath.
Liability is other thing, my lord, defaulter is other thing. Page para 35 of the judgment, my lord, clarified all the facts, my lord. How come he came to
Seen
the
that.
writ court, my lord?
Okay. Yes, Mr. Nath.
Malad. Malad, in fact, this daily settlement has been done pursuant to the order of your lordship, Malad, on 30th of June. Malad, lordship has directed us to call for the hang a notice and call for the applications whoever offers. And the person who has been given the daily settlement now, he has offered the highest and he has been given. Well, so for the defaulter thing is concerned, kindly come to the earlier order at page 72.
Yes, I'm there.
Lordship. Well, in fact, we considering them defaulter, we issued notice, and the honorable court ultimately in the order has Roman 4 kindly similar. The order dated 6/2/2023 is only interfered to the extent indicated herein above, that is, the specific observation and finding to the effect that the petitioner is a defaulter and liable to pay 64,98,306 as revenue. The entitlement of the respondent states have been specifically dealt in paragraph 35 herein above. Well, in fact, they were directed to give us representation because some areas were not handed over to them at that point of time. According to them, according to us, they are liable to pay. So that representation has been submitted. To that extent, I will take the instruction what has happened to that representation. So far, as per this judgment, Malad, they are not to be treated as a defaulter, and accordingly, they have submitted this application that has been considered. We found that he has offered the highest amount, the 5,500 Malad, at page 91, Lordship will find. The petitioner has offered 5,100 per day. Page 91, Malad. The last 4 paragraphs. The 4th highest bid offered by MS Soipa Sotia Means Somai Committee Limited at rupees 5,500 was found to be the valid highest bid. The read petitioner offered 5,100 per day, which was the 7th highest bid on the other hand. So therefore, Malad, ultimately we have in the last paragraph, we have considered the highest bid.
Yes.
Lordship. So Malad, on that limited issue raised now, so for the default, whether the private respondent is a defaulter or not, that Lordship, the representation, what decision they have taken, let me take the instruction on that.
Yes.
Basically, my submission is the same, Malad. So far as the question of defaulter is concerned, Malad, that 64 lakh demand was made. It was definitely made. But then, Malad, we had some grounds for which, Malad, this was interfered with. So, Malad, this order, Malad, at page 72 is very clear, Malad, 4, Malad. Roman 4, it's very clear that to the extent has been interfered with. Malad, so therefore, the question of defaulter doesn't remain at this stage. What the honorable court has directed, Malad, is that in paragraph, Malad, in page paragraph 17, 18, and 19, Malad. Sorry, so page 69, 70, and 71, in paragraph 35, Malad, is that our application for remission is to be decided because we had raised some points, Malad, with regard to non-handing over of the fishery as a whole, and there are certain other, Malad, issues which were involved, Malad. Therefore, Malad, in that context, Malad, this honorable court held, Malad, we are not defaulter, first of all, and secondly, our remission application has been directed to be decided, and we were asked to file this application within 10 days. We had done so, Malad, and that is pending before the authorities. In that view of the matter, in fact, the honorable court has also said that, my lord, we will be entitled even to participate in a regular process if the decision within of us being defaulter is not done at least 10 days prior to calling of the new tender. So that to that extent that liberty has been given to us, so that the last moment we are declared as a defaulter and we do not have a right to challenge that also.
Where is that observation?
That observation is very much there, my lord, at page, my lord, paragraph 35, Lordship may kindly take up, my lord.
You know, Mr. Nath, it is the government who is inviting all these litigations so far as fishery is concerned. And I'll tell you the reason why. Number one, the fishery is under the Assam, the land regarding the fishery is under the land revenue regulation. So a fishery may be on the land, maybe on the water body. But the land for fishery is given under the Assam Land and Revenue Regulation. In your there's an Act of 53. So every time you have to demarcate the boundary and then give it to these people. You don't have a definite boundary, and your authorities, for every drop of the hat, starts a re-verification process in respect of the land. But what essentially you have not done is that you have not limited the fishery area into this. Now this Dibrugarh fishery,
Yes,
in the
Dibru part one.
last litigation he was handling, we found that it is nearly 91 bigha land. Nowadays, with the encroachment on the land, the land being used for other uses, you won't have 91 bighas of land. So therefore, litigation, you are inviting yourself. You're not demarcating, you're just going by the boundary. You're not looking into it. If the land is actually a fishery land or there is agriculture going on, there is third-party rights created, pattas have been issued inside that land. So you're not doing. Therefore, as a state council, you must also give them an advice that this is the litigation which is being promoted by state. Can you imagine 91 bighas of land in Dibrugarh, which is close to eco-sensitive zone, being declared as a fishery? Now the forest department comes and says that this is a eco-sensitive zone. Your fishery department comes and said, no, it is not without outside the boundary. The government doesn't speak in one voice.
That is the main difficulty.
So we'll issue a notice to the chief secretary if required, because he must come down. You can't play with the Kaziranga area that easily. And that litigation of Mr. Borme was an eye-opener. You see, there is a fishery in the just 1 kilometer outside the eco-sensitive zone. To go into that fishery, you have to travel from the Kaziranga main forest area. Huh? Dibru-Saikha National Park. Yes, we are right. Thank you.
In fact, in this particular, that similar thing happened, Malik.
Brahmaputra
It's
part,
because of that. Malik.
Then the deputy commissioner comes. He gives a stay order that you can't sell your fish in that market.
in fact, the Brahmaputra part 3.
No, but you see the fallacy of the state. It doesn't speak in one language.
Correct.
One department issues a fishery, other department stays sale of the fishery, but catching of fish is not stayed.
Not state.
And then the forest department, fishery department, and the deputy commissioner are speaking in 3 different languages.
In fact, as regard this Brahmaputra part 3, in one case, 2 affidavits have come with 2 stamps.
No.
Ultimately, one
You
of
see,
the-
my intention is not to give a sermon. What I'm saying is that in a given case, if it is a eco-sensitive zone, by way of a judicial order, will interfere and will send it for adjudication before the Green Tribunal.
No, now, Malad, this has been.
The state revenue will be stopped.
This has been demarcated now. That particular Brahmaputra part 3, that is the portion
No,
which
no.
follows.
So,
That has been demarcated.
Mr. Math,
Lordship,
you see, you are on owner of a 1 kattha land.
Lordship,
Has your land been ever redemarcated time and again?
No.
Then why it is happening for fishery? Every time this fishery tenders come, then you ask for demarcation, and every authority is ready and willing to do it.
I in fact asked once, I asked them, they said that the course of the river, it changes with time. Because these fisheries are in Brahmaputra. The river is not static. It changes with time. Sometimes it goes to that side, sometimes.
No, it's okay. But have you seen in the land and river regulation with regard to alluvial and diluvial soil?
Correct.
What does it say?
Well, pattas were given in those particular lands.
No. You are missing the point. You see, once the land is gone in the river, the patta vanishes. And when it comes back, the patta is revived.
It is pattas.
So therefore, you see, when you are giving it, you have a definite, you see, you are, the deputy commissioner is the authority on land. He sits over in the, what you call this, what is it called? Payment of damages on what you call this flooding.
Lordship,
What is it called? What is the department called?
so revenue and disaster management.
No, no, not disaster doesn't give, whatever be, the revenue department pays compensation to those people. So therefore you have a definite, what you call, no, you have definite information about what land has been lost. So why you need a demarcation every time? 1 acre of land, you have 1 acre of land. 10 lessers have gone in the flood. That is documented. You get a compensation for that. If claimed, if you are within that, you get a compensation. So why in the it can't be an automatic filling? Why only at the time of tender?
It is a continuous.
At the time of tender, this demarcation will come. Then everything is stopped. Daily fishery you are giving. Now in daily fishery, where is that boundary again?
Part 3 has not been given.
No.
Only
I'm not on
part
that.
1 and 2, where the no difficulty is there, that has been given.
There is no difficulty. Then why allowed in the High Court order to say that he is not a defaulter in regard to that? Why it was not qualified when you were there, when the state was represented? Why in this order you did not say that he is a defaulter not in respect of 1, not in respect of 3, in this 5-part fisheries?
In fact, not we, according to us, he is a defaulter.
No. You see,
Yes,
he
yes, that
has
was-
read
that
para 35. He has read this para
Yes,
page 72 of the order.
yes.
Now, if he is a defaulter, why did the state did not take the trouble of informing the court that he is a defaulter in respect of those part where there is no dispute?
No, actually, it's a composite feature. It's a composite feature. That
So
is why
therefore, you see, you have space everywhere to give leave to all these big time fisheries. Everywhere you have scope where litigation can multiply.
Correct. No, Lordship, I fully agree with your Lordship. What has fallen from the picture.
So now once
Otherwise-
one person will come that no, I was not given the full fishery. Government will say that in one case, now you are saying the same story, that no, in one part there is no dispute with regard to the land. He has been given the full fishery. Why this is not documented in the in your affidavits? Supreme Court has used the words. In certain cases, mistakes are purchased. Mr. Nath, in one of the Supreme Court judgment, it is stated that in government, mistakes are purchased. It's not my words. Words of Supreme Court.
In fishery case, it's
No, it's happened.
like.
Okay.
So, but in paragraph 35, there's no interface with that. You will see, madam. May I read, madam? Another
35.
relevant aspect of the matter,
Okay, 35 is which para?
page 70, madam. Page
70.
70, paragraph 35. Another relevant aspect of the matter that arises in the submission of the learned counsel of the petitioner is that the state respondent has been directed to consider the case of the petitioner for entitlement of remission. The respondent should not, state should not treat the petitioner as defaulted till such a decision is arrived at, and the order dated 6/2023, insofar as holding the petitioner as defaulter is regard to interfere with. The learned counsel further submitted that one of the requirements for submitting a valid tender is a non-encumbrance certificate, and the said certificate would not be issued to the petitioner. The petitioner held a default at the nick of time, and as such, some protection in this court is required to give to the petitioner if the respondent state gives a decision on the petitioner's representation at the 11th hour. The court, upon consideration of the peculiar facts of the case, is of the opinion that taking into consideration that the respondents have been directed to re-examine, reconsider the case of the petitioner for remission of the revenue, it will be in the interest of justice to interfere with the order dated 6/2023 to the extent only where the petitioner has been held to be a defaulter and liable to pay 64 lakhs and all. It is made clear that this interference to the order dated 6/2023 shall not mean that the decision to go for fresh settlement is interfered with, or for that matter, the respondent state is not entitled to revenue for the period of settlement till 6/2023. It is reiterated that the respondent state take forthwith steps for settling the scheduled fishery on such part of the scheduled fishery after redefining by way of a tender process. The respondent state shall consider the representation if so submitted within time as specifically directed infra, and thereupon shall be entitled to such amounts so adjudged in accordance with law. As regards the question of treating the petitioner to be a defaulter,
at the 11th hour, this court is of the opinion that if the decision is taken in the representation is within 10 days from the last date of submission of the tender in respect of the scheduled fishery or such part of the scheduled fishery, then the petitioner cannot be treated as a defaulter for not making the payment of the amounts to judge. So, my lord, even that liberty has also been granted to us. So that order of defaulter, which my learned friend is trying to say that I'm a defaulter, that's been interfered with, my lord. There is no finding of defaulter as such, my lord. And this remission has been allowed, directed to be considered, whether I'm entitled to, my lord, pay or whether, my lord, it is liable to pay, my lord, whether, my lord, the non-payment was justified. Because we had raised several grounds, my lord, in the writ petition.
It's okay.
So that my lord, lordship will see para 33, my lord, page 68, his position will be clear, my lord. He all along, my lord, from initial stage overstayed. Lordship kindly have a look, page 68, para 33. Page 68, para 33. For the reasons above, therefore, this court of the opinion, the order of dated so cannot be interfered. Therefore, the settlement period for the petitioner has to be constituted for 7 years from 12/12/13 to 21/2/20. The said observation, however, requests another aspect of the matter is the distinct various proceeding filed before the court, interim order being passed. Petitioner was allowed to continue the settlement beyond the said period. He stayed over period. It would, however, be relevant to mention that the bite order dated 6 to.
It's okay. I have taken note of that.
Lordship, meaning thereby, my lord, he's as on date, my lord, he stayed overstayed.
That was
More than, my lord, he has stayed.
No. That
And now, my lord,
now it is daily basis tender.
That's
my
not,
lord,
that is
even though daily basis
In
is
fact, that is
taken,
an
my lord,
example.
if I am not entitled, other higher bidder is also there, my lord. Why choose particular number 4, my lord?
Okay. Heard. Mr. J. Borbial and counsel for the petitioner. Mr. D. Nath Leonard, Leonard, senior government advocate appearing for the state respondent numbers
1 to 5.
1 to 5. And Mr. M. Datta Leonard,
1 to 4.
counsel appearing for respondent number 6. Was appeared by virtue of by virtue of filing a caveat. Next paragraph. At the outset, it may be mentioned that this court by judgment and order dated 2/3/2023 passed in WPC 8109 of 2017, amongst others, had directed to complete the process of sale of scheduled fishery within 3 months from the date of the said judgment and order. On a court query, it has come to the notice of the court that the process of regular sale of the fishery has not been completed within the time allowed, i.e. 3 months from the date of from 2/3/2023. Therefore, the court had put the learned senior government advocate to notice as to why a suo motu contempt should not be initiated for failure to abide by the directions contained in the order dated 2/3/2023. On the said court query, the learned senior government advocate took some time to obtain instructions, and on a very short notice has obtained instructions from the Office of the Deputy Commissioner, Dibrugarh, to the effect that the boundary of the fisheries have already been determined by conducting a joint survey on 31/5/2023, and that the boundary description of Dibru Brahmaputra fishery and Brahmaputra part PT part dash Roman 3 fishery has been determined
That's supposed to be my left 3, 4, 5.
and sent and the redefined boundary proposal has been submitted to the government white letter for notification of the fishery boundary white letter dated 15/7/2023. It is submitted that in due course of time, appropriate steps will be taken to comply with the order of the court. With the said explanation tendered by the learned senior government advocate, the court does not propose is not inclined to issue notice at this stage. Next paragraph. By filing this writ petition, next paragraph, by filing this writ petition in Article 226 of the Constitution of India, the legality and validity of the order dated 6/7/2023 issued by the
Joint Secretary, Madam, page 92.
page
92.
92. Issued by the Joint Secretary of the Government of Assam, Fishery Department, thereby settling the fishery, settling the Brahmaputra part Roman 3, Roman 4, and Roman 5 in Dibrugarh district on daily basis was made in favor of respondent number
5.
5.
6.
6.
6.
This is 6, make it not 5. 6 is challenged, has been challenged. Next paragraph, issue notice, return over in, we'll make it 2 weeks. Return over after 2 weeks, give a date. Especially returnable on so and so. Requisite extra copies of the petition we served on the learned additional senior government advocate within 2 days. Next paragraph, heard both sides on the prayer for interim relief. So it is noted that pursuant to the hearing before referred order dated 2/3/2023, the sale of the fishery on daily basis was notified in accordance with the directions of the court, and it appears that 7 numbers of bids were submitted till the appointed time. Now, what is this page 91? Please see page 91. In the second paragraph, it writes 7 bids. In the after 2 paragraphs, it says 8 bids. How 7 has become into 8? I never knew that bids also carried.
I'll also get the clarification.
Because in flights it happens. Passenger carrying travels in the flight, and when it comes down, the additional passenger.
Correct, correct. I'll answer.
On flip 6, who are the flip 6 is silent.
It will be 8 because 8 highest bidder has quoted 2,000 rupees per day.
So this 7 is wrong.
7 is possibly wrong.
Okay, make it 8.
I'll check.
Instead of 7, make it 8. First one. From the interim order, it appears that first 3 highest bidders were disqualified. And the respondent numbers 6 was the 4th highest bidder, offering a sum of rupees 5,500 as
5100.
no 5,500. You are 5,100. Then we allow the repetition.
Sorry, repetition 500. Sorry.
Huh.
Sorry.
5,500, which was found to be a highest valid bid, daily bid. Whereas the petitioner had offered 7th highest bid of rupees 5,100 per day. Therefore, the court finds that the bid submitted by the respondent number 6 was the highest bid. Was the highest bid. Next paragraph. Insofar as the allegation of the petitioner that the respondent number 6 was a defaulter is concerned, the court finds that the status of the petitioner as defaulter has been saved by order dated 2/3/2023. First of all, under such circumstances, the court does not find this to be a fit case to give to pass any interim order, and accordingly, therefore interim relief is refused. Next paragraph, list on so-and-so. 4/8/2022.
And just one thing, my lord, let the government to bring the status of the respondent, my lord, whether is it important or not.
No, I'm not saying that right now.
No,
It's a daily
decision the
basis.
government has to take, my lord.
And-
Otherwise, if it does not submit representation, meaning thereby is it important.
You have
Always
remedies.
submitted,
You
already
have
submitted
the
long time
remedies.
back, but within 10
They'll
days.
file their affidavits.
Yes.
They know what is going to come.
Yes, I have always submitted in 10 days. Well.
They know what is going to come. There are certain things which are not to be said.
Item 15.
In interim to the Lordship, I am the 3rd highest bidder, Lordship. They have rejected arbitrarily my.
Will issue notice and that
Lordship, kindly see the page.
I am not saying it. I am not saying
I am
it.
the 3rd highest bidder. He is the 4th highest bidder, Lordship, illegally rejecting my bid, Lordship, allowed.
No, if it is whether it is legal or illegal, we'll have to determine.
I am offered also more.
No, that is okay. We'll see that.
550, Lordship, I am 560, Lordship.
No. You see, once you are technically rejected, this means you are out. In your what do you call by an interim order, I am not putting you to that place.
I am illegally out.
It's okay.
Everything on record, Lordship, what he stated about my.
No, you see,
the interim
people,
order.
the courts having more wisdom than me.
Yes, Lord.
I've already decided that if you are aggrieved, you can move the civil court for damages. These are words of wisdom.
Only for getting the
No, I don't know,
in
this
favor of
wisdom is, I am not the originator of this wisdom filled statement. There are other very good authorities. You look so serious, Mr. Chaudhary behind is so serious. He's not appreciating those words of wisdom.
My submission is that Lordship only accommodating the private respondent, Lordship, my bid was illegally rejected.
No, but you see, I can't put it in a
Everything
position.
was
You
before-
show me any authority where by rejecting the bid at the motion stage, the status of a bidder has been altered and put to award of tender in an interim order. You show me one authority on the point. I can only issue a notice at this stage. By an interim order, I can't allow your petition. That I can't do. But Mr. ABT Hawk, the counsel for the petitioner, Mr. D. Nath, Leonard, additional senior government advocate, appearing for respondent numbers 1 to 5, and Mr. M. Tata, Leonard, counsel appearing for respondent number 6, was filed on the strength of a caveat. Next paragraph. The petitioner claims that despite submitting a third highest bid, his tender was illegally held to be not valid. On a flimsy ground of the secretary of the society being removed as secretary of the society. Next. Accordingly, the impugn order dated 6/7/2023 is assailed in the present petition filed under Article 226 of the Constitution of India. Issue notice including notice of the prayer for interim relief returnable same day, returnable so and so. Requisite extra copies of the writ should be served on the additional senior government advocate in course of the day. Next paragraph. As notice has been issued on the prayer for interim relief, the court expects the respondents to file their affidavit in opposition positively at least 2 days prior to the next date of listing. List on so and so.
My interim may be
Affidavits.
considered on the next day.
I have issued a notice on interim prayer.
Yes,
Till date not handed over the Vichari to the private respondent, as per my knowledge.
how he will be benefited? If that is
I
for-
don't know. I can just smile.
No.
Item 17 for admission.
Please, Lordship.
In this case, Lordship, I am seeing apology, Lordship. Due to our fault, Lordship, we have not communicated my lord's last order, Lordship. So Lordship may give at least 3 weeks time, we will communicate it and obtain the instruction.
Make it 2 weeks because the investigation
Lordship,
is not being done.
Lordship.
Well, this is 2016
Lordship, FIR of
16
2016.
FIR.
Lordship, and we have filed affidavit and status report on that is status report, my lord is not satisfied, and so Lordship has directed us to Lordship. Up to this.
I've seen that.
So Lordship give 2 weeks
We'll
time.
give it 2 weeks time.
Lordship.
We'll give them one license. Mr. D. Thousand, counsel for the petitioner is present. Mr. K. Goel, an additional senior government advocate, submits that due to inadvertence, the order of this court dated 2/6/2023 could not be communicated. Next, in view of such statement, the inadvertent delay on part of the state is condoned. Next paragraph. Now 2 weeks time is granted to produce the status report of investigation in a seal cover in terms of order dated 2/6/2023. Next paragraph, the learned additional senior government advocate shall transmit copy of order dated 2/6/2023 as well as order passed today to the superintendent of police, Dima Hasa, Haflong. Next paragraph, list after 2 weeks, give a date.
7th of August.
This instead of 2 weeks, make it in that order. First part. 7.
7th of August.
Okay, 7/8.
Lordship.
Okay.
Oblige, Lordship.
Item 18.
Yes, Mr. Das.
Yes. So this matter, my lord, pertains to reduction of forest royalty. There was earlier, my lord, this has been decided, settled by.
Yes,
our division bench.
PWD, Mr. Nath was there.
Division bench has settled this matter. I moved this, I was a council member.
No, I
And
am
it
aware
was
of it.
before division bench. Now, my lord, what they are saying, it is your lordship knows coordinate bench also, my lord, is also agreeing with that. Then also single bench also, the latest judgment of the single bench, where all has been distinguished, certain judgments they want to say. Now they are saying.
So just give me 2 minutes. Let Mr. Nath be here. Because this is
Forest
PWD.
Department.
You are conducting PWD.
PWD.
Work.
Now they are raising a very new point. They have said the writ petition is not maintainable. They are raising some new points now.
Oh, okay. Just give a scroll for SC PWD and SC Forest. Just wait for some time.
Yes.
You are enjoying an interim order.
No, I am in, there is no interim order. My forest royalty is been deducted. So now that the entire, it should be refunded back to us.
Okay, question of refund is there.
A refund
Okay.
is there.
You have made a prayer also for refund.
Yes, yes, we
Okay.
made a prayer for refund.
Just wait for some time.
Yes.
Just wait for some time. There's an order a few days back of the single bench of this court was produced. It was a recent judgment. Dr. Saraf had produced
The
it.
division bench is settlement. There is a judgment of a division bench.
No, I don't know, a very recent judgment of a
No,
single
I
bench
just
of this
saw,
court.
my lord, initially it was moved before learned single judge. Long back.
No,
Forest
no, no,
royalty-
now there's a recent judgment.
Yes.
Dr. Ashok Saraf had placed before me a few days back
Uh-huh.
of a coordinate bench.
Hmm.
You just ask him.
Coordinate bench.
Of single bench.
Uh.
Dr. Saraf had moved about just before the vacation.
No, my lord, I know, my lord, all
Okay,
the
okay.
coordinate bench judgment, I relied.
Okay, okay,
Coordinate, because I was the council which moved before coordinate bench.
okay.
State has preferred an appeal against the order of learned say long back judgment against the learned single judge. Then the division bench says confirm the, so say yes, how can you deduct the forest royalty?
Okay.
If you want to it should be part of the contract. It was not a part of the contract.
That's it. It should be a part of the contract.
Part of the contract.
Only those contracts where it is a part of contract that is saved.
That yes.
Okay.
Otherwise not.
Okay. Just wait for some time.
Yeah.
Item 19.
May I please, your lordship?
Yes.
This matter pertains to ex gratia payment on road accident, your lordship.
Ex gratia.
Yes, lordship. And the disposal of the material lordship and direct the respondent to the for releasing the amount, your lordship.
Just a moment.
Simple prayer, lordship.
Yes, who has filed this affidavit?
Number 3, your lordship.
Respondent 3. I can understand what is being sought to be conveyed by this affidavit.
Lordship, from paragraph 5 and 6, Lordship, the NOK was not submitted by the petitioner. Next of kin certificate is required to Lordship.
No, but you see, this next of kin certificate is issued by somebody under the deputy commissioner. Why should the petitioner run for it?
He has to apply, Lordship.
You have not applied for NOK.
Lordship, I have already applied, your lordship.
Where is that?
In the presentation, your lordship, kindly page 31.
Page 31.
Yes, lordship. This is the representation, your lordship. And lordship, page number 32, your lordship, I have submitted the next and each certificate, your lordship. And close part, your lordship, bottom part.
Just a moment.
To read this, it's a kind of election.
No, we'll ask the deputy commissioner to move in the corridors of his own office and get it. You see, he is right. Paragraph 9, paragraph 5, he makes a statement that application has been made. This document at which page you said, annexure 9?
Paragraph 5 is for the Lordship application for release of ex gratia, Lordship.
31 page,
No,
your
no.
lordship.
Annexure 9, page 31, Lordship.
Page 31.
Page 31, Lordship.
You see, that is an application.
Application, your lordship. Before the.
This is the application, Lordship, not for NOK, Lordship.
And
Next
lordship,
of kin certificate, it is not.
32, I have enclosed the document, your lordship. This is the next and each certificate, I have enclosed, your lordship, enclosed part, your lordship.
Huh.
All documents I have submitted, your lordship.
See, here it is not enclosed, Lordship, whether NOK is submitted or not. Lordship.
No, that is okay, but you
Lordship.
see, he may
Lordship,
have made a mistake.
Lordship, let petitioner may produce the NOK,
You
Lordship.
produce
Then
the, give a copy to Mr.
Lordship
Gogoi.
may on the basis of that, Lordship may dispose of with the direction, Lordship.
No, take instructions, we'll take it up next week. Give a copy of that NOK.
NOK page, your lordship, kindly see 16 page, your lordship. I have enclosed.
Page
16. 16, your lordship.
16.
My expedition, your lordship. Annexure 1.
16. Dispose of from it.
This is the next and each certificate, your lordship. TGC Saddam Hussein, your lordship.
Just a moment, just a moment.
And 17, your lordship. Family members, your lordship.
Just a moment.
On the basis of that, my lord may dispose of
Yeah,
the.
dispose it of them.
Lordship may dispose of.
And Mr.
Yes, Islam.
S. Islam, counsel for the petitioner, also heard Ms. G. Hazarikal and standing counsel for Revenue and Disaster Management Department, representing respondent number 1, and Mr. K. Gogoi and an additional senior government advocate appearing for respondent numbers 2 to 6.
Lordship, I am for 3 to 6, Lordship. 2 is fine.
Achha, 3 to 6.
Finance.
Finance.
My lord may record an AS only is present.
Yes, Mr. A. Chalia.
Lordship.
And Mr. A. Chalia and standing counsel for the finance department appearing for respondent number 2. Next paragraph. In brief, the case of the petitioner is that the son of the petitioner, late, what is the name?
Namely Saddam Hussein.
Namely Saddam Hussein, while riding on his cycle from Dhupdhara, DHARA to Uthakoti, KUTHAKOTI on NH 37 was hit by vehicle number AS 25, capital CC 3846 at about 7 AM, 7:30 AM on 3/10/2017 near the Dhupdhara Daily Bazaar. Stop. The grievously injured son of the petitioner was taken to Bikashi, BIKASHI Model Hospital, where he succumbed to his injuries. So accordingly, Dhupdhara PS case number 130 of 2017 under section 209/304 capital A IPC was registered. Stop. In course of time, charge sheet dated charge sheet number 80 of 2017 dated 13/12/2017 was submitted. Stop. The petitioner submitted next of kin certificate in respect of the deceased son, comma, proof of identity of the petitioner and the death certificate of the deceased son. And in terms of notification dated 15/11/2014, the petitioner applied for grant of ex gratia to the next of kin of persons killed during due to accident. Which entitled the petitioner to a ex gratia of rupees 2 lakh. Stop. The next paragraph, the petitioner projects that the application for ex gratia was submitted before the office of the Deputy Commissioner, Gwalpara, on 20/9/2022. But as the ex gratia was not released to the petitioner, the present writ petition has been filed under Article 226 of the Constitution of India. Next paragraph. It is the learned additional senior government advocate has referred to the affidavit in opposition filed by respondent number 3. Next paragraph, the said affidavit has been perused, and it appears that the said affidavit filed on 5/4/2023 by one Rishiraj HRISHIRAJ Das, Assistant Commissioner Gwalpara, has been mechanically filed without verifying the contents of the writ petition. Stop. The said affidavit filed on behalf of respondent number 3 does not take into account the annexes 1, 2, 3, and 4 appended to the writ petition, which are number 1, next of kin certificate, number 2, voter ID card, number 3, EAN, PAN of the petitioner, comma, number 4, death certificate of the deceased. Full stop. It appears that the stand taken in this said affidavit is that the petitioner is required to submit no objection certificate from the other family members, from the other next of kins. Full stop. In the said affidavit, there is no statement made that the petitioner was made aware of any requirement to be complied with. Full stop. If the authorities are aware that no objection from the next of kins, other next of kins are required the authorities should have ought to have given the petitioner notice to comply with this with the requirement. Full stop. The same having not been done, comma, if the deputy commissioner or the or any other authority in the district of Goalpara has any doubt with regard to the no objection from the next of kin, the court is inclined to direct the Deputy Commissioner Goalpara or any subordinate authority authorized by him to visit the house of the petitioner to collect such information. Full stop. However, at this stage, when the petitioner has been waiting for ex gratia corona, the authorities it would not be open to the authorities to now ask the petitioner to submit any other document, but they would have to visit the house of the petitioner to collect such information. Next paragraph. As the petitioner has already produced a copy of NOK, that is next of kin certificate, it will be open to the office of the Deputy Commissioner, Goalpara, to cause an appropriate inquiry and to release ex gratia to the petitioner within an outer period of 60 days from the date of the order, from the date of receipt of a certificate copy of the order. Next paragraph, the petitioner shall produce a certificate copy of this order before the office of the Deputy Commissioner, bring the order to the notice of the corresponding authorities. Great patience stands disposed of. Restraint allowed to the extent as indicated above. The parties are left to bear their own cost. Yes.
Deed of
18. Mr. Das was there. Yes. Is this a covered matter?
Well,
It's a covered matter.
covered, but I had tried to carve out one difference, one exception. It was, my lord, I may be wrong, my lord.
No, you may be right, but we have a superior authority.
So I was stressing on a point, and that point, when Justice Methi was finally going to hear it, then it came that one of the judgments I'm relying, which is one of the major judgments of Justice Methi, was a part. So it was released from his bench. And so, my lord, we have, if my lordship permits, we have to start de novo, my lord. There are certain, I may be wrong, my lord. My whole thinking may be wrong, but I have a case, small, my lord.
Sure.
Just now, my lord,
my whole gamut of my argument was, my lord, that to enforce my 226, my lord, the remedy claim must be public law remedy, my lord. That was one of my arguments. I may be wrong, my lord, and I had relied upon Kerala SCB, Escorts India Private Limited, and I'm a bit handicapped now, my lord, because I was under the impression that we are as another court, my lord. So just have come just.
Das, when can you take it up?
I need the my lord. It is.
You choose a date.
So day after Thursday also it can be taken.
No, Thursdays and Tuesdays, I am having some top of the list matters. All matters are coming up. Weekdays will be, motion days will be better.
Monday?
Monday, okay. What says it will be represented? On the prayer made by Mr. D. Gogoi, Learning Council, Study Council for the Forest Department.
First department.
Matter stands adjourned today, list on 24/7/2023.
I apologize, my lord. Because
No, it's okay.
Apologize.
Item number 27, there is an urgency. There's a report.
Just
also by
one by one, you'll have to just get it recorded with Mr. Das.
Day after
One by one.
tomorrow.
No, I'm not saying anything because he'll have to make the adjustments.
Item
As per the
21,
list.
the interim needs to be extended.
Okay.
Can be.
Item 21. Item. So only just one by one, give it to the court master.
As
We'll
far as
take
the
note
date
of-
is concerned, my junior will.
My lord, my interim order will be getting over today.
Just tell Mr. Das. Correct, one by one. Give him some time. Come one by one, he'll take note of.
In my this extension of the any date, I just know.
It's okay. Let him take that form.
May-
Mr. Alam,
I think I cannot 55.
just give him
25.
some time. One by one, he'll
25.
take note of.
Maybe Day
He-
after
he-
tomorrow, I mean, the factory is.
I can't say about the day after tomorrow, but he'll take note of it.
Also, the report, the factory is closed for a long time. That's.
Okay, which factory?
Purbanchal, report was called for when the government, the report has come.
I have
You
received.
got the interest. Give a short date in this matter to
Yeah.
Mr. Ajay Das.
Deeply appreciated.
Because you see, all those matters after the, before the vacations are now coming up.
Yes.
So therefore, it's not a case of me adjusting today's matter day after tomorrow, but it's a long pending, what do you call it? List which is now before Mr. Das. Correct. Give
I'm
some time to
hopefully-
make some adjustment and take it up.
Deeply obliged.
Junior कोई भी अपना 31. Binda कोई.
Yeah.